Okay. Ready, Kathy?
Yes, sir.
All right, so let's go on record. So we have one case on the calendar today. It's 16 SV 89 Maynard versus Snap and McGee. What we're going to do is today, discovery's closed. We're going to do motions now to figure out where we're at and let you all start preparing for trial. Or obviously, if the Snap's motion is successful, then I guess we'll just be having a trial with everybody else. What I'm looking for is, I don't know if you all added up your page count since May 1st, but just to say it out loud, it was 12,774 pages. I know because I finally broke down and counted them yesterday. Good job. That's got to be some sort of record. You all are still my favorite attorneys. Don't tell the attorneys I said that. With that said, I say that number with a bit of a purpose, which is that I didn't make it through all 12,774 pages, but I feel like I have the beats. And what I'm looking for first is, for record purposes, I'm going to have each of y'all introduce yourselves, even though all of us know all of us. And that way there's a good record of who's here and what are you doing here. And then have you tell me and make certain that I have lined up with what you're looking for me today. I just got a phone call, somebody logging in. I'm really hesitant to let that. Yeah, my mic's on, but it's over here. Let me see who that is. So, oh, your virtual person, in-house counsel
Probably in-house, yeah.
disappeared, and then replaced by the call-in user. Give me just a second.
Someone in-house asked us for a link, so I'm assuming that's who it is, but I don't know that.
Okay, give me just a second. We'll see if we can make this work. Okay, we're also live streaming to YouTube, so if they want to watch that way, they can.
Why don't you just text her that?
I sent them both.
Oh, you
I mean,
did?
yeah.
Yeah, just
That might be why she disappeared.
We'll communicate that to the client, Connor.
Okay. All right, that sounds fine. Just log that. All right, well, whoever that is, I let them in, but I'm not allowing them to unmute themselves. Okay, y'all ready? So let's start the plaintiff's table. Y'all introduce yourselves, who you represent.
Yes, Your Honor. Naveen Ramachandrappa on behalf of the plaintiffs.
Dwayne Adams on behalf of the plaintiffs.
Michael Neff on behalf of the plaintiffs.
Scott Masterson for Snap.
Paul Moore for Snap.
And Dow, Pistol McGee.
All right. So tell me, I'm going to start with the defense because they filed the majority of the motions for me to hear. So Mr. Masterson, will you please just give me your punch list for me today so I can make certain that your punch list and my punch list match?
Sure, Judge. So we conferred a little before we got started. We were trying to figure out the most logical order to avoid redundancy in argument. But to answer your question, obviously, Snap filed a motion for summary judgment. They have moved to exclude in whole or part the expert opinions of plaintiff's experts, Bowie, Persinger, Alter, and then there is sort of a composite medical motion that it deals with Doctors Harbin,
Snyder,
right? And who's the last one?
Giles.
And Giles.
Giles. Okay. All right.
Could be Giles.
And then y'all wanted to file some stuff under seal. Did y'all have it? Was there any issue between the two sides on the request to file under seal?
It's a bit complicated. I would say that we have objections to certain designations that have been made in the case generally. So as long as that's understood and I believe that's been resolved. As long as that's noted, the motion that they did file was just to file Adam Alter's report under seal. And we agree that given its designation right now, it should be filed under seal. We have a similar motion, but again, we still have objections to whether those documents should actually be treated as confidential. But given that they are currently treated as confidential, we agree that both sides' motions.
Well, I'll just say that you agree as to 9:24 a.m. this morning, and at 9:25, we'll revisit the question.
Okay, sounds good.
Okay. All right, Mr. Maston, back to you. Anything else?
I don't think so, Your Honor.
Okay, well, good. That's what matches. All right, let's go over to you.
Yeah, so the only motion that we have on our side, I believe, is that motion under seal. And the only other thing I'll add, just as we're sort of previewing our day, I will be handling plaintiff's response or argument to summary judgment to the alter motion. Mr. Adams is going to handle the Boyd Persinger motions, and then Mr. Neff is going to handle the combined Huckman Snyder jobs.
Okay, perfect.
I forgot one thing.
No, that's
I'm
great.
sorry.
Why we do housekeeping?
So I sort of did it, but I didn't. The plaintiffs attached an affidavit from Mr. Persinger, who I know Your Honor will recall from a prior hearing. And we've moved alternatively to either strike it for consideration this stage, given its new opinions undisclosed, or to depose him before the court considers it on that obviously discrete point that is the subject matter of this affidavit. I forgot that one.
Okay, so do you want me to fold that into the Persinger hearing, or do you want me to mark that as a separate item?
I think it can be folded in, and however Your Honor wants to handle it is fine with us, but I think it can be folded in.
Okay.
We agree with that.
All right, well, we'll just fold that into the Persinger question generally, and then we'll go from there. All right, well, good. Well, that makes me feel a little bit better that I took your 12,774 pages and I had a pretty good idea of what we were doing. So there's hope for me yet. Okay. Any other housekeeping? I'm sorry, let me ask you one quick. Do you have any preference, Mr. Masterson, as to what order we address these issues today?
Not particularly.
Okay. Because I don't either, and I'm happy to defer if y'all have an agreement or you have a preference.
But may I give you my thoughts, and then maybe we can come to conclusions?
Yes.
Together? So the only real interest I have, obviously, is for all of them to be considered by the court, which I know they will. At the end of the day, the expert motions do affect the summary judgment motion insofar as a lack of proof or an exclusion of a part of an opinion may remove something that the plaintiffs would argue creates a question of fact for the jury. In arguing those motions, right, in arguing the summary judgment, I will be careful if we go first with it, not to go ahead and make the expert arguments as I go along, but they do dovetail, right? So on one hand, I would say if we did the experts first, that would make more sense and you wouldn't have to repeat it in summary judgment. The plaintiff's preference, I think they articulated before we started, was the opposite way around. At the end of the day, it doesn't matter to me. I'm happy to proceed with summary judgment. Maybe that gives context, and maybe it'll shorten the experts on the backside of it. So those are my thoughts. I really don't have a strong preference, and I'm ready to proceed in any way the court directs.
Okay.
Yeah, Mr. Masterson accurately described our position, which is that we think it's more efficient to do summary judgment first, then hear the experts. It's not like Your Honor is going to decide the expert questions at the bench right after the argument. So it's not like we're going to have to just skip that when it comes to summary judgment. But Mr. Masterson is also correct. It's not a strong preference. It is a preference, and we'll leave it to Your Honor.
Okay. All things, let me check something really quick. All right. My inclination, again, I'm kind of with you all, is this really is a close call. Both thoughts on that have some merit. I think for our purposes today, I'd rather start with the motion for summary judgment and just let you pull me into the big picture and use that as both your motion and your 30-foot flyover. Because again, I'm a little bit more blind than I normally am because I wasn't able to get through all of your documents before the hearing. And I think that would really help me make certain that what I think I'm seeing matches what you're arguing to me. And I do think that at the other end, it'll streamline, but again, I'm with both of you all that this is not one of those very clear, easy, one's right, one's wrong. It's just a flip of the coin. Do you all need any time to kind of stop and get reset? And I'll say again, I say this each time, it's just us in the courtroom with no jury present, that you are welcome to stand at the podium. You're welcome to be seated. If you are seated and you're making your argument or at your table, just use your microphone so that makes certain that Kathy can hear you loud and clear. And obviously, if she waves at any of us, we all stop and figure out because she is the most important person in the courtroom. It is not me. So, Kathy, did you need anything else? All right. And I'm assuming y'all want this taken down and okay, that's just,
Yes.
that was a foregone conclusion that I just realized I should at least say out loud. Do you want it taken down and are you splitting it?
Yes.
All right. Ms. Gower, I know you don't have a lot of items on the agenda today, but obviously, as always, do you have any housekeeping you would like to address with the court today?
Yes, sir.
Okay. All right. Well, obviously, if you have anything, let me know. Again, there's no jury presence. It's just us. So if anybody needs a break at any point, you just wave your hand and we'll take a break. I'm planning on taking them about every hour as we go. That's kind of my thing. Just quick stretch your legs, step to the restroom. Just so you know, since there's a bunch of y'all, there's a restroom back in the jury room here. There's a restroom out in the court lobby there. And if you go out this door and take a left and go up one flight on the elevator, there's a bathroom just beside that elevator. So there's bathrooms all around everywhere. And I don't believe there's any court going on the second floor. So anybody have any other hands? What's
Child sports on the second floor.
okay? So there is somebody in the courtroom, but that doesn't affect y'all going into the bathroom. So, and again, if anybody wants a cup of coffee at any point, there's the bailiffs keep the coffee pot back there stocked. Anything else? Okay. All right, then we're ready. So, Mr. Masterson, the floor is yours.
Thank you, Your Honor. May it please the court and Kathy. I will present for the court's jurisdiction SNAP's motion for summary judgment. The court has lived with this case as long as the parties. And so I know that Your Honor knows the basic facts of this case. A couple of things in the 12,000 pages that I'll start with is to sort of point out a couple of fallacies that seem to be repeated. And the first one is, well, this has already been decided by the Court of Appeals or Supreme Court, and it's a foregone conclusion that this motion should be denied. The standard review, as Your Honor undoubtedly knows, at the motion to dismiss stage is different than it becomes at this stage of the proceedings. The Supreme Court and the Court of Appeals on the two issues decided those based on a standard review on a motion to dismiss. In other words, they assumed all the evidence was true. And so what I would, a second. There we go. Sorry, technical difficulty there. So what I would say is that at this point now, as Your Honor pointed out, discovery being closed, we move to answering the question of whether or not the plaintiffs have now come forth with evidence supporting the claims that they've made. The summary judgment standard, I don't think I've ever argued it out loud in the summary judgment hearing, right? And it's because everybody skips that part of the brief, okay? In this case, I would urge the court not to do that, right? And the reason is because there's two unique things here that require a little bit more careful look than might otherwise be present in your typical case. And the first one is that the first basis of our motion for summary judgment, grouping these things into broad categories, is an affirmative defense. Okay, and SNAP in its briefs have set forth the evidence we believe support and that is undisputed in the case, which then shifts the burden to the plaintiff to present evidence to the contrary. We would submit that they have not, but I primarily bring that up to point out that burden shifting as it relates to the doctrine of acceptable consequences. Secondly, for a product liability case, that where you're alleging design defect, the standard of review there necessarily requires a look at expert testimony. And when I said earlier in our preview of when we were discussing the order here, why it's important or how the experts dovetail into the decision for the court here, it's important, right, to understand whether or not the experts set forth an opinion to begin with, right, and then also whether that opinion comes from someone who's qualified to give it, and whether they use scientific methodology in order to get there. Okay, and so I'm going to try not to argue during this phase of the argument the qualifications and the methodology to get there. I just want to go ahead and note that we obviously challenge those to some extent. We haven't moved to exclude every single opinion that every single expert has, as they've suggested, but we have pointed out where they've come up short in our view and under Georgia law. All right, so getting to it, okay, like I said, there's really two distinct grounds, although each of them have subparts, but I want to be more broad than that. So first of all, before I know that a lot of pages have been devoted to Snapchat, a lot of pages and this software application, and whether or not it has immunity under a federal statute, lots of pages, which by the way, we do not waive, I should say, that argument, understanding the rulings have been made previously. But lots of pages have been devoted to that. A lot of pages have been devoted, 30 some hours deposing Snap witnesses. Trips have been made to California multiple times. But before you ever get to the point where you look at how Snap interfaces or comes into play in this case or does not, which I'll get to on the product liability portion, you first just have to look at this like it's a car wreck. And so I would urge the court to first analyze the car wreck before it analyzes Snap. And so to sort of preview the basics here, right? We believe, and we have asserted evidence is undisputed that Mr. Maynard could have avoided this accident, and it was within his ability and knowledge to do so, and he failed to do so. And there's no evidence to the contrary. There's no evidence that Snap negligently designed the speed filter. There's no evidence that the negligent design of the speed filter is the cause, the proximate cause of the crash and plaintiff's damages. And then I won't spend a lot of time on these, but we've also moved separately for summary judgment on plaintiff's punitive damages claim and on their attorney's fees claim. And I'll get to those later. Moving on, please. Okay, so first things first, right? We have a car crash involving two vehicles, right? And the Lovejoy police goes out and they investigate what happened in the crash, and they interview the witnesses. They don't interview Mr. Maynard. He was injured, and his health was the most important thing, and so he was not interviewed. But all of the passengers and the driver in the other car were interviewed, and what results in most cases a police report, right? And so what we learned from the police report is that the witnesses in the other car all testified that Mr. Maynard was coming out of his apartment complex. Why is that important? His apartment complex is important because he's familiar with the intersection. His wife testified that he drives it at night, right? And that he goes to Atlanta because I guess it's probably a better market for Uber. He was doing Ubering and Uber or Lyft. And so he's turning right out of this apartment complex, and he crosses over 2 lanes of traffic into the lane that is occupied by Miss McGee driving her vehicle. And so the reason most likely that he goes into that lane is because we just drove it coming to the court this morning, right? And he has to go and make a U-turn to go back north on that road to get to Atlanta, where he's going to do Ubering. And so the basic facts as it relates to what occurred in relation to the 2 vehicles is largely undisputed. And what I will say is that while Miss McGee denies that she was going 90 miles an hour, while one of the witnesses in the car was asked how fast she was going and said she was going, 60, somewhere in the 60s miles per hour. For purposes of this part of my argument, the court can go ahead and assume, or will assume arguendo, that Miss McGee was speeding and that she was distracted. Like we'll just set that aside and assume that she was doing those things and analyze it that way. So what did the Lovejoy police officer conclude? And I know Your Honor has probably seen lots of police reports, and I always have to pull that key that goes with it because I can never remember what the contributing factors and everything are. But I did that here, right? And so we look at what the Lovejoy police officer said, and he analyzed what he saw there at the scene. Right? He analyzed what the witnesses said. One of the witnesses, by the way, did say that she was speeding. Right? I think Ms. McCarty said she's going 100 miles an hour. And with that knowledge, right, you look at what he concludes, right, which remains largely undisputed in this case. So first, he asked, was the vision obscured for either of the two witnesses? And one means no. I'll represent to the court from the key that I read over the weekend. And then they list contributing factors as police officers typically do. And he lists 11 and he lists 4, which are failure to yield and also failure to or improper lane change. There's what 11 and 4 are. Okay, and so no citations were issued, but the police officer, in terms of his evidence, and I'll get to an affidavit in a moment, determined that Mr. Maynard did 2 things, right? Didn't yield and improperly changed lanes. And contributing factors related to Miss McGee, he found none, even with evidence from a witness saying she was speeding. Next slide. Right, so each of the witnesses gave testimony to the driver, to the police officer who's investigating. Go ahead. Those are in the record, but all of them testify consistently that Mr. Maynard pulled out in front of him. Next slide. Oh, there it is. I did provide the factors here. And so I guess what I would say about this is that after interviewing those individuals who witnessed the accident and Miss McGee, who was the driver, he could have, but did not, list as contributing factors talking or texting on a telephone, distracted driving, reckless driving, aggressive driving, racing, speeding. And the reason for that is because nobody at the scene said anything that like they did 8 or 9 months later in May of the next year about Snapchat. Nobody talked about her using her phone, and no one told the officer anything about this speed filter or using it to get to 100 miles an hour, which they later would. But again, you can assume for purposes of this argument that she was speeding and distracted. Next slide. All right, so how to make a right turn. Okay, I just went to where I would send my kids when they had to take a driver's license exam, and I looked at the driver's manual, and it tells you how to make a right turn. And we all know this intuitively, right? But the reason I'm boring or going through this with the court is that how you make a right turn is important, right? And it's something that is known, or at least constructively known, at the point when you get your driver's license, which for Mr. Maynard was probably many years before this. But there's no doubt and no dispute in the evidence that Mr. Maynard had made a lot of right turns, most likely in his lifetime. And when you turn like Mr. Maynard did and you make a right turn, right, you turn into the immediate right lane closest to the shoulder or the side of where you made the turn. You don't go across 2 lanes of traffic. You go into the immediate right lane, right? And what it says here, it says, make the turn in such a way as to end up in the right lane of the street into which you have turned, and avoid entering any other lane of traffic.
That's in the bottom right corner there.
That's in the bottom right corner, and here I'll provide, for the record, I've got a paper copy of this. I can provide it to court, when I wrap up, but yeah, so the driver's manual explains how to make a right turn. It also explains the law, governing right of way. And what I would submit is that when before Mr. Maynard, there's a yield sign, by the way, is the traffic control coming out of that apartment complex. Can we go back to the diagram real quick? There we go. So, in the diagram, which is probably not to scale, but, when he's making the right turn there, it's a little bit more split than is shown in that diagram. And Mr. Maynard has a yield sign. And when presented with a yield sign, Georgia law requires that you yield, right? And so Mr. Maynard makes two decisions. One, he has to decide whether to go onto that road and make the right turn, right? Look both ways before entering traffic. And then going back forward, please, Paul. Yeah. Then to make a right turn appropriately and legally, he is to go into the right-hand turn, the immediate right-hand lane. And what we know from plaintiff's expert, Sean Alexander, who's a former Georgia State patrol officer, what we know from Mr. Alexander and his opinions is that he got the black box data out of the Mitsubishi, right? So the Mitsubishi data contains speed information for 4 seconds before the impact, and it also contains the angle of the steering wheel. Okay. And so what Mr. Alexander testified when Mr. Ford took his deposition is that the steering wheel for 4 seconds before impact shows at all times it's turning to the right. Okay. What does that tell us? Right. That tells us that when you're sitting perpendicular to the road, right, you got to turn your steering wheel to the right in order to make a right-hand turn. At no time in those 4 seconds upon entering that highway, did Mr. Maynard turn his steering wheel to the left, is what Mr. Alexander said, right? Which means if you pull into the right-hand lane and then you would have to turn your steering wheel to the left, right, to merge into the left lane. That did not happen. And so what I'll show you in a minute is it's undisputed from their expert that Mr. Alexander, who went out and did a reconstruction of this, that Mr. Maynard turned across 2 lanes of traffic, got into the right lane and then merged into the left lane. Next slide. Okay, so in addition, right, to being demonstrating negligence on Mr. Maynard's part, it's also negligence per se, because under OCGA 4648, it describes driving on roadways lane for traffic. And so vehicles shall be driven as nearly as practicable entirely within a single lane and shall not be moved from such lane until the driver has first ascertained such movement can be made with safety. The driver has to ascertain that, and it's knowledge that Georgia drivers are charged with. Next slide. Likewise, 46-120 describes methods of turning in intersections. Again, the right turn, this is just sort of a codification of what's in the driver's manual, right? That you make a right turn, and the right turn should be made as close as practical to the right-hand curb or edge of the roadway. The reasons for this are obvious, right? You don't want people pulling onto the highway or pulling onto a Georgia state road and going across 2 lanes of traffic when there's like into the fast lane of the road. Next slide, please. All right. You play that. So what
when
is
Mr. Maynard began to pull out? When Mr. Maynard,
Maynard.
That's on me. Mine was turned down, not yours. How about that?
So in terms of what happened, right? Because we do bear the burden of coming forth with evidence on this affirmative defense of avoidable consequences. And so in addition to what I've been through so far, Ms. McGee testified in her deposition as follows.
when Mr. Maynard began to pull out, as you described earlier in your testimony, did you believe that he was coming into the left lane?
No, I thought he would stay in his lane, and never in a million years did I think he was going to come into my lane.
And once you realized that he was coming into your lane, what did you do?
I immediately slammed into my brakes.
Do you, I know you probably didn't take any measurements, but do you have any estimate of the length of braking? You know what I mean, the skidding or anything like that?
1 second. I mean, it was immediate. Like, the braking did absolutely nothing. He was already there. And when I braked, it didn't even stop me before the point of collision.
All right, next slide. All right, and so continuing on again, you saw the police report of Officer Ken Evans, but he also provided an affidavit which we submitted with our pleadings, wherein he describes his arrival to the accident scene. What he saw in terms of the vehicles involved in the accident, and his interview of the witnesses that he was able to interview. Next slide. All right, and so what he concludes is that the impact occurred in the far left lane of travel, with the right front of Miss McGee's car contacting the left rear portion of Mr. Maynard's. Now, why is that important? What Mr. Alexander confirms, plaintiff's expert, is that impact indicates that he was not fully into the left lane at the time that she impacts him. So, as Mr. Alexander will testify, or I'll play some of his deposition just in a minute, he doesn't dispute that he came across, Mr. Maynard did, 2 lanes of traffic into the lane where she was traveling. All right, and then I did not cite McGee on the night of the crash on the consistent statements from the occupants of Miss McGee's vehicle that Mr. Maynard had suddenly pulled out in front of them. Had Mr. Maynard not been injured or unconscious, I would have cited Mr. Maynard for causing the crash. The plaintiffs did not take Mr. Evans' deposition. This is unchallenged or unpierced in terms of evidence. And as I said, Mr. Alexander, their former state trooper expert, testifies consistently with how the accident happened. Next slide. Hold on just a second, Paul. This is Sean Alexander, plaintiff's expert accident reconstruction.
No, and all I'm trying to establish is just a kind of an understanding of what the pre-crash data shows us.
Oh, yes. Well,
Okay.
pre-crash data shows that it's accelerating and it's coming from the end point of the exit.
So,
Right.
From the exit of the apartment complex, Mr. Maynard is making a right turn coming out of the apartment complex.
Going across the 2 lanes of traffic.
He's got his foot on the gas, going across the 2 lanes of traffic.
There you go.
Yes,
That's correct.
and he accelerates from 11 to 23 miles an hour as he crosses those 2 lanes of traffic
In the last 4 seconds, that's correct.
in the last 4 seconds.
Correct.
So as he's exited the apartment complex onto Terra Boulevard, he does not touch the brakes, right?
No, I don't see him touching the brakes once he goes back to the gas, if that's what you're asking.
Yes, and so he does not slow down. He's accelerating, correct?
He is accelerating, and we have his rate of acceleration right here.
Right, so he's accelerating from 11 to 23 miles an hour as he's crossing from the exit of the apartment complex into the left lane of traffic.
That's correct.
Okay.
All right, and so Mr. Alexander confirms that he crossed the 2 lanes of traffic, and he's accelerating during that period of time, 4 seconds, I think he mentions. But combined with Miss McGee's testimony, right, the only in the last portion of that turn does he enter into her lane. Why is that significant related to these speeds? As he just told you, the acceleration coming out of an apartment complex, I guess in a Mitsubishi Outlander, he gets to 23 miles an hour. Okay. And so he enters a lane that whether you're going 55, 65, 85, 90 miles an hour, when you don't stay in the right lane and yield to oncoming traffic in the left, and one car's going 55 miles an hour, or one car's going 80 miles an hour, 90 miles an hour, even 45 miles an hour, and you're going 23, it's going to present a difficult challenge to the driver. And so, as we'll see, Mr. Alexander testifies about this. Next slide, please.
No, and all I'm trying to establish is just a kind of an
That's the same
understanding of what the
slide.
pre-crash data shows.
Okay, and so I've attached. This is just reference to that testimony. Next slide, please. Okay, and so here's a I guess a Google Earth or an overhead view. Remember when I said that intersection looks a little different than the diagram? So you can see there's a vehicle in the perpendicular, I guess, meant to represent Mr. Maynard's car. And he comes up to the yield there to turn right. He has to make two decisions, right? When he looks back down the road that was unobstructed. And one thing that is important, I guess, to understand and is unchallenged in the evidence, including from plaintiff's accident reconstruction, is that you can see for a half mile, right, back up that road. You'll hear the testimony in a moment, but Mr. Alexander confirms that there's nothing obstructing his view, right? When he pulls up to the yield sign, he's looking back and he can see 22 football fields, right? And there's nothing obstructing his view of the headlights. Okay. And he makes the first decision, which is to turn onto the road at all, right? And then he, from there, makes the decision not to stay in the right-hand lane and follow the law, but to go across two lanes into the left-hand lane, right? And there's nothing in the evidence, nor would there likely be, right, in the way of any testimony from Mr. Maynard. He was deposed, but he doesn't recall, understandably so, the accident. But as we'll see from the case law I'll cite to in a moment, there needs to be some challenge to the evidence that he would not appreciate the danger of pulling in front of oncoming traffic, regardless of what speed that traffic was going. And there is no such testimony, right? So in short, plaintiff's expert testified that he agrees that he crossed two lanes of travel. He agrees that the accident happens. You see how in the top, the right-hand corner of this diagram Mr. Alexander made, the vehicle is at an angle. The front vehicle is at an angle. That's what I guess that's a better depiction of what I was trying to describe, right? That the car's still coming into the lane when the impact occurred. And based on Ms. McGee's testimony, again, unchallenged by Mr. Alexander or anybody else, he surprises her by making that maneuver without yielding to his oncoming traffic. All right, or oncoming vehicle. Next slide. All right, so I've already been through this, but I used the scale there, right, to just demonstrate that it's undisputed, and Sean Alexander agrees that this just represents 10 football fields, but you got 10 football fields of you sitting there at the perpendicular deciding whether to turn. Next slide. All right, and so this is more testimony from Mr. Alexander.
So if Mr. Maynard was looking back north, then he would have been able to see McGee's lights, then, right?
Lights, that's correct. If he looks back around that curve,
right,
then he can see the lights of the vehicle. That's
so
correct.
as he's turning right, Mr. Maynard can see McGee's headlights coming.
As long as she's within that distance, yes.
As long as she's within a half a mile.
That's correct.
Got it. Okay. All right. And you don't have any evidence or any reason that you can think of as to why Mr. Maynard would not have been able to see McGee's car as she approached from within half a mile.
Objection.
I don't know that he didn't see it.
Okay, and I appreciate that, but my specific question was, do you have any evidence or any reason to believe that he did not see it?
No, that's what I was saying. I have no evidence he didn't see it, so I don't know if he did or did not.
Okay.
Does that make sense, man?
Sure.
You say you phrase it as, do I have evidence that he shouldn't see it or couldn't see it or whatever, and I'm like, I can just say, I don't know if he saw it or not. That's outside the scope that I've done.
Right, but you don't have any evidence that anything was obstructing him or preventing him from seeing it coming.
Oh, do we have evidence? There's nothing obstructing his view. There's nothing physically obstruction. The only obstruction would be his car, the geometry of his car.
All right, and so what Mr. Alexander confirms is that he has no opinion and doesn't offer any testimony conflicting. One, that there was a clear line of sight, nothing was obstructing his view. Two, he could see the headlights. And three, he knows of no evidence supporting anything that would have prevented Mr. Maynard from seeing it. So could have, should have is not as important as it was possible to see, and he cannot say or create a question of fact on whether he should have been able to see that in terms of making a decision, or really two decisions, of turning to begin with and then turning and then crossing two lanes of traffic rather than going into the first lane and yielding into the left. Next.
So Mr. Maynard was.
Okay, so the undisputed evidence, when you get through it, and I know it's lots of pages, but the undisputed evidence is that Mr. Maynard was familiar with the intersection and often navigated at night, right? Because that's when he drove his Uber. He was on his way to Atlanta. His wife testified to that. And that would have required him to make a U-turn from the left lane, probably another 0.2 or so of a mile down there. It's undisputed that he had a legal duty to yield to traffic traveling south before turning out of the apartment complex. He had a clear line of sight and he could see McGee's vehicle headlights for half a mile. He had a duty to turn into the immediate right-hand lane under the law on a 4-lane road. He had a duty not to leave the right-hand lane and enter the left lane until it was safe to do so under the failure to yield law. Maynard turned across 2 lanes into McGee's lane of travel without ever straightening the wheel. That comes directly from Mr. Alexander's pulling of the data from the car. The investigating officer determined Maynard failed to yield and changed lanes improperly at the scene. Mr. Maynard never turned the steering wheel left, so he had not completed his turn. The angle of the vehicle also establishes that when the impact occurred. Plaintiff's expert testified that the accident does not happen, regardless of McGee's speed or distraction, if Mr. McGee does not unlawfully enter her lane of traffic. Plaintiff's expert testifies that the accident does not happen, regardless of Ms. McGee's speed or distraction, if Mr. Maynard does not unlawfully enter her lane of travel. And there's no contrary evidence in the record. There's no facts that are inconsistent with what I've been through. There's no opinions that are inconsistent with what I've been through. And so the evidence is that first, Mr. Maynard, right, could have and should have, right, followed the law in making the decisions he did that night. And it's undisputed that the consequences were avoidable, right? What does that mean? That means that if he doesn't turn to begin with because there's a car coming that he can see for a half a mile, 22 football fields, and he stays put until she passes. And by the way, Miss McGee testifies there weren't any other cars on the road. There's not like there's 2 or 3 cars and there's some confusion about whose headlights it would have been. It's really just her and him. Right. And he can see those headlights and he's coming down the road. And if he sits tight, then the accident doesn't happen. If he turns into the right lane and stays there until she passes, I guess at 90 or 107 miles an hour or whatever it is, the impact doesn't occur. Instead, he turns across both lanes and into her lane of traffic. And that was avoidable if he had followed the law. Next slide, please. Right. And so the plaintiff, once we have set forth this evidence, the plaintiff has the burden at this stage before the court to show admissible evidence to rebut this affirmative defense. And they need affidavits from witnesses with personal knowledge, or they need an expert opinion, but they don't. Instead, their plaintiff accident reconstruction admits that what happened is consistent with this defense. And in the absence of admissible evidence, summary judgment is appropriate. it's not often granted on affirmative defenses. It's not often granted in cases related to causation. However, Georgia law clearly dictates that it is to be granted when there is no admissible evidence supporting any other theory of causation. I mean, they might suggest something like, well, later one of the witnesses said that, he might have looked back, or he might have done this, or he might have done that. But what was in Mr. Maynard's mind can't be testified to in an admissible fashion in this courtroom. At least I hope not, without it being speculative as to what Mr. Maynard was thinking at the time that this occurred. Next slide, please. Okay, and so the primary case that we've cited to is Weston versus Transport and Stringer at 304 Georgia App 84, right? And so this just affirms what I paraphrased a moment ago, right? That the plaintiff, an affirmative defense, either a trial or summary judgment, that the plaintiff by ordinary care could have avoided the consequences to himself or caused by the defendant's negligence. So when I said the court can assume right now, for purposes of this argument, that she was negligent too, she was speeding or distracted or whatever it is they're claiming related to this speed filter. Obviously that's denied, but I think for now, right, we can assume that she was speeding or otherwise negligent, right? And it says, although the issue of whether the plaintiff exercised due diligence for her own safety is ordinarily reserved for the jury, it may be summarily adjudicated where the plaintiff's knowledge of the risk is clear and palpable. There is no evidence that in this case, that the risk of crossing two lanes of traffic, even in a 55 mile an hour, is not clear and palpable. And so it goes on in the the Weston case to say that the plaintiff, if they want to survive summary judgment, once this evidence is presented, then if the plaintiff can't meet the burden of production, the defendant's entitled to summary judgment as a matter of law. And so the Weston case is a similar, not identical, traffic situation. In the Weston case, the court found that Weston failed to come forward with any evidence that the decedent lacked knowledge of the danger she faced, right? And so one of the arguments you might hear from plaintiffs is, well, Mr. Maynard doesn't remember the accident. But again, in Weston, the person was killed and obviously couldn't provide testimony, and summary judgment was still affirmed, right? And so in this instance, despite her knowledge, the decedent, of the open and obvious risk, the decedent elected not to change course, but to move forward enough into the southbound through lane of the highway that she reached a point of no return, as Weston contends, and suffered the tragic consequences of her misjudgment. And when Mr. Maynard made the decision to turn across two lanes of traffic, to not turn into the immediate right-hand lane, and to continue on without straightening up in the right-hand lane before turning his wheel left and going into the left-hand lane, that was a misjudgment, and it absolutely had tragic consequences here. Even assuming that each of the appellees was negligent, the Weston case goes on to say, right? So we can assume that here, and that their negligence combined to create the hazard. That's real familiar from plaintiff's complaint in this case, that the decedent encountered that day. The evidence established as a matter of law that the decedent, in the exercise of ordinary care, could have avoided the consequences to herself caused by the appellee's negligence. And so this is on all fours with the situation presented in this case, and we would suggest that this is authority that, given any evidence to the contrary, would dictate summary judgment in Snap's favor as one of those defendants who is alleged to have combined to create a hazard. Next. All right. So what does Mr. Alexander, the plaintiff's expert, say?
Got it. So this crash, does this crash happen if Maynard stays in the right lane?
And you keep everything else the same?
Yes, sir.
No.
So no matter how fast McGee's driving, she's going to be driving 91 miles an hour, 107 miles an hour, or 60 miles an hour. if Maynard stays in the right lane, this crash does not occur, correct?
Yeah, that's, if you don't occupy the same space at the same time, another object doesn't happen. That's why you show if the car's back there, it's not there, it don't happen. But yeah, you got to be in the same space. So if it's not over there, obviously it doesn't happen.
Right, okay. So it doesn't matter if she's distracted, doesn't matter where she's looking. If she's in the left lane and he's in the right lane, the crash doesn't happen, right?
Yeah, they shouldn't hit each other.
Okay. So
Next slide.
got it.
Okay, and so we're requesting that the court grant summary judgment on our affirmative defense of avoidable consequences. Sort of a corollary, right, is that Maynard has raised in paragraph 73 to 75 of their complaint, no action or omission by Mr. Maynard or Mrs. Maynard caused or contributed to the cause of the wreck, and then restate that in a couple of different ways. The court also should grant summary judgment as to Mr. Maynard's contributory negligence. They're really just a function of the same thing, but there is no evidence inconsistent or refuting or creating a genuine issue of material fact that Mr. Maynard crossing two lanes is not contributory negligence. And so we would submit that summary judgment is appropriate as to those claims by plaintiff, that summary judgment be entered and judgment as a matter of law be entered on avoidable consequences defense, which goes into causation for the accident. We're not really asking for a causation determination. This is an affirmative defense to liability that Mr. Maynard could have and should have and had knowledge to of the consequences of not doing so, and made the decision to put himself in the harm of someone else's negligence that could have been avoided. Next slide. Okay, so that's the first portion or half of our summary judgment argument. Before I move to product liability, does the court have any questions or?
No, as always, y'all all do an amazing job of giving me stuff ahead of time, breaking it down into bite-sized pieces. Granted, there's a lot of bite-sized pieces on this one, but I appreciate the effort y'all put in. I'm tracking so far, and I will stop you if you lose me. I promise.
Okay, thanks, Judge. I just wanted to offer before I change gears here. All right, and so as many pages, right, that have been dedicated to it and depositions taken and everything else, right? Ultimately, what we have is, in terms of evidence for the first point, right, is the testimony of the witnesses in the car, right? An accident reconstruction is hired and paid for, and who testified on behalf of the plaintiff, the Lovejoy police officer who they never deposed or pierced his opinion. And all of that is consistent with the defense. And so the analysis stops there, right? If summary judgment is granted as to this defense and to the contributory negligence, we don't have to move to this portion of our brief. Understanding that we're not going to get a ruling right now, I'll continue on. So the second part is plaintiffs allege that there's a product liability claim against SNAP. And these are the counts from their complaint, so we don't get confused based on argument today. They essentially make a design defect claim, and they also make a claim that Snapchat's disclaimer, which I think can be clearly read as warning, I don't know what else that would mean, are also inadequate, unreasonable, and knowingly ineffective. And so I want to spend my time this morning talking about the evidence related to the warning and about the design of the product. And what I would say and should say for the record is that at the end of the day, what this is a software application, and it's unchallenged that this software application is on a phone, and it's unchallenged that McGee had never used what they say is defective about it, the speed filter, before allegedly accepting the testimony of some fact witnesses, which we obviously disagree with. But the first time should use it. There's nothing conflicting that saying that should ever use the speed filter before, right? And so presumably the argument is that the design defect is the speed filter, although that is not articulated in any meaningful fashion in these three paragraphs. Secondly, the warning presumably refers to the warning, do not snap and drive, which it's undisputed, would be displayed in front of, at the time of use by anybody using the speed filter for the first time in the Snapchat app. So moving forward. Okay, so design defects are not ordinary negligence. They require an expert, right? And an expert analyzes a design defect. And in this instance, while they may say it's simple, it's not simple. It's complex coding, software design, data engineering, and it's done by people with advanced degrees from probably good colleges, right? And so the design, manufacturing, the safety standards that I'll get to in a moment, that their expert purports to have knowledge about, are emerging at this period of time. And it's sort of important to stop for a second and put in context the benefit of hindsight. Okay, so in terms of analyzing the defect, like the design and engineering of the software application that contains the speed filter, we got to remember that this happened in or around 2012, 2013 time period, right? The first smartphone, right, is about 2007 or 2008, right, in the world, right? And one of the things that the plaintiffs have urged repeatedly in their, 6,400, their share of those pages, is a lot of stuff that happened or has happened since, including some horrible accidents where people were injured. Okay. But in terms of the analysis of a design defect, it has to be made at the time of the design and the release of the product. If this wasn't a software application and it was a chainsaw or a blender, right, it would be how it was designed and when it was sold, right? And then the question is it merchantable for its intended use under Georgia law? And so I say all that to say, I would submit to the court that it should not be persuaded by things that happen later or information that developed as the state of the art related to smartphones, smartphone apps, laws and regulations related to driving an automobile while using your phone, or hands-free regulations, to put into context this period of time from 2007 to 2013, and from 2013 to 2015 when this accident occurred, and then even now over a decade later, right? There's been a lot of change, and there's been a lot of there's been a lot of changes in development of the state of the art and the knowledge. And so I know I'm overstating this, but I'm doing it on purpose. The analysis about Snap and the design of this product should be made looking at the period when it was designed, right? And then to do so, whether the product's design deviates from an acceptable standard of care, right? So this is a medical malpractice case, nor am I trying to make it one, but undoubtedly, right, engineers and people who are manufacturing something like a software application, coders, the people who are running a company that is making at the time, a very new and state-of-the-art product, they are professional people. This is not ordinary negligence. And so you have to look at the standard of care. First, you have to define it, and then you have to look at the standard of care in terms of reasonableness. I'm sure you'll hear from Naveen that that this design defects cases really sound in negligence, but but it's not ordinary negligence. It's negligence of a similarly situated professional person who's following a standard of care in designing something like this, right? And then how the deviation could cause harm, right? And whether and how alternative designs could have prevented the injury. And these matters, which is the dovetailing into the expert motions, these matters are of scientific, technical, or specialized knowledge that fall under Georgia Code 24/702's definition of an expert. And the experts got to be qualified in relevant engineering, safety field, or warnings, and able to be able to explain how the design contributed to the injury. Next slide. Okay, and so once the experts in this case are carefully analyzed for qualification and their opinions are carefully looked at the end of the day, the evidence and related to design, nobody is able to articulate a reasonably foreseeable risk of harm from the intended use of the product, right? There's no dispute that this was not intended, right? It was not intended to be used in the manner that is alleged that Ms. McGee used it in, right? They have to prove that it was a foreseeable misuse, which is illegal and an intentional conduct, essentially weaponizing it to hurt others. I would submit to the court that when you parse through all of the words in their briefing and the words in their expert reports and look at the substance of them, they fail to meet that by presenting evidence that's admissible in this case to base an opinion that Snap had some reasonable knowledge of a foreseeable risk of misuse that would be used illegally and intentionally to hurt others. The plaintiff, obviously Snap denies the allegations. In presenting experts, right, they presented a computer science professor who the last time he ever worked in industry or having anything to do with software engineering was in the late 1980s. Right? He's never worked as a software engineer in any of the period of time that's applicable to the advent, hell, of telephones, but also of smartphones and applications. And they presented a psychologist who's written some books and got on the media and podcast tours, but he's not qualified he's not a software engineer. He's not an engineer. He's never worked at a company designing or manufacturing these type of products. And so they don't have a qualified expert. And then secondly, those experts don't actually do any kind of scientific methodology. They just give conclusions. And so at the end of the day, right, you need an expert opinion if the standard for looking under the Banks case, as plaintiff insists, is that there's a risk benefit analysis, right, that is supposed to be performed, and that risk benefit analysis should lead you to a different design, or because the design fails the risk benefit test, it shouldn't be included. They need an expert to say, right, a reasonable design engineer would have done a risk benefit analysis. I've done a risk benefit analysis, and these should have been the conclusions, and I'm qualified to give those opinions. Okay, and I'll show you the case law that supports this, but there is case law that supports that an expert who is qualified needs to come in and look at the professional standard of care for software engineers or designers or data scientists, and then actually do the risk utility analysis, not just say they didn't do one, right? We don't need an expert to say they didn't do one, right? The jury can hear that testimony from the witness. Not just they didn't do them, but if they had done one, it would have reasonably led them to a conclusion other than the one they reached related to design, right? What you'll find as we go through this is neither of their experts, whether qualified or not, did a risk utility analysis, and they admit to that. Next, experts' opinion on foreseeability based on hindsight, which I previewed for the court, which Dr. Alter does a lot of, and events subsequent to the accident, not at the time of the design, or between the time of the design and Mr. Maynard's automobile accident are not relevant to the design defect analysis. Right. And last I've been through this, I won't repeat it. The qualifications in terms of having knowledge or experience as a software designer, engineer, anywhere approaching the field in the modern smartphone software application world is also needed. And then they do not set forth an expert, despite the pleading that Snap's warning was insufficient or inadequate or whatever it says in that paragraph. They do not snap and drive warning. They don't present anybody who says that wasn't a reasonable solution to the foreseeable misuse of distracted driving, right? And so do not snap and drive. They're expert. I think everybody in this courtroom, and as far as I know, there's no one that challenges in this case that do not snap and drive warns not to do the thing that Miss McGee is alleged to have done that caused this accident. And so ultimately, the presence of the warning, like one might expect, does indicate, right, that there was some discussion around people really just using telephones in general and the apps on them and getting distracted while driving. And whether it's using the temperature filter, the speed filter, taking a picture or a selfie and sending it to your girlfriend, whatever it is, right? Do not snap and drive was warned on this application, and that's undisputed. There's terms and conditions that say that you're not supposed to use this app in this manner that people agree to when they download it to their phone. That's also unchallenged or unpierced. They just say nobody reads those things. That may be true, but you're supposed to read them, and it says in the terms and conditions that they've been read and accepted. And there's no dispute from Miss McGee that she didn't, in fact, do so and accept those. In fact, she'll testify, as I'll show you later, that she absolutely knew that she wasn't to text and drive, she wasn't to snap and drive, and that she understood those warnings. So, if nothing else on this claim, the plaintiff's failure to warn claim should be dismissed summarily. Next slide. Okay, so what's the facts? What's the evidence here to make this analysis about a reasonable design and the foreseeability about this illegal use in this period of time in 2013 before it was released? So you got 30 hours or so of corporate representative deposition testimony. They deposed, as your Honor will recall, the court let them take the founder and CEO of Evan's deposition. They were given affidavits. I'll take a moment on a refresher here. They were given affidavits from people, because your Honor will recall, based on the timing of all the motions around this, when they take the 30 hours of corporate representatives from SNAP after sending us a notice with, 4011 topics, those were taken like in 2023, 24 time period, a long time after this. But the investigation by the plaintiffs into the Blizzard data and the reliability of it and those things really started a long time before that. A delegation of them went out in June, I think, of 2016, right? And they met with, and I think Naveen was there, and I think Dwayne was there, and they were able to ask questions to Mr. Fong Lee, okay? And you'll hear his name a number of times in the motions today. Fong Lee is a data scientist, data engineer who in 2016 had the knowledge because he was there and he had been there in the preceding year in 2015. And so I bring this up at this stage to tell you that there are affidavits, I think, from 4 SNAP individuals in the attached to our motion that describe what they did to investigate it, how the app works, and other things that remain unchallenged now. At no time after going out and meeting with Mr. Fong Lee, I don't know what Naveen will stand up and say about that meeting. He was there, I wasn't. However, there's affidavit from Mr. Trigg related to that meeting, but at no point, the point being, at no point after that Did they challenge those affidavits? They didn't take their depositions. They didn't ask to take their depositions. The testimony remains unchallenged. In fact, you'll see when we get to Dr. Bowie's motion that Dr. Bowie, their computer science professor expert, doesn't challenge and cannot state to a reasonable degree of scientific certainty any challenge to the content of those data engineers and software engineers affidavits. And then last, you have documentary evidence dated before and after the release of the app and the date of the accident, September 10, 2015. And as I said, I just submit that a line be drawn, right, in the documentary evidence that did not exist or doesn't reference something existing in the period of time when the app was being designed. It's compelling and would be compelling to a jury, but one of the reasons the gatekeeping function of the court is so important is that if you allow evidence to demonstrate foreseeability from documents or witnesses that didn't exist yet at the time the foreseeability analysis has taken place, that is horribly prejudicial to the defendant and unfair. Next slide. All right, so I had somebody do a word search, right? Because I was like, well, what did the SNAP people say about foreseeability? I don't know how many pages are there. It might be 12,002, Judge. Three times did the plaintiffs ask SNAP people about foreseeability, okay? So did SNAP foresee how the speed filter could be used dangerously? Yes. How could the speed filter have been used dangerously? By using while snapping and driving. All right. And you'll recall that the warning says, do not snap and drive. Next. And that's, no, sorry. I meant next, I'm moving to the other portion of the slide. Sorry, Judge. That comes from CC's deposition. I call her CC not to be informal or disrespectful, but because I have a hard time pronouncing her last name. It's Moraganis, I think. But in any event, this is from her 23 deposition at page 105 and 152 and 153, right? Next thing. This is from Nona's deposition. And well, how about if used foreseeably, has SNAP noticed that there are hazards that are foreseeable when teenagers use SNAP? No, right? And so she says no, not if used properly. Evan Spiegel was deposed, and he was asked exactly one question on foreseeable. And remember, Mr. Spiegel, I think part of the reason that it was allowed to take the apex of the corporation's deposition is he was there, right? And so the other two were witnesses that SNAP had to designate and have them prepare, because some of the witnesses who gave the affidavits were no longer at the company, right? 8 or 9 years had passed. And so the last instance of the word foresee in any of the SNAP deposition testimony is, considering the maturity of teenagers, did SNAP foresee that many of them would not read and abide by the terms of service? Remember, I told you that those are terms of service that they agreed to. That's not what we foresee. Okay, next slide. So that's the totality of evidence from SNAP, right? Witnesses on which one could analyze the standard of care or foreseeability as an expert witness. Okay, obviously there's documentary evidence, but I'm talking about testimony from a witness. Okay, so evidence of speed filter as a design calls Miss McGee to be addicted or influenced. Why am I bringing this up at this point? I don't know, because it's the next slide. It's the truth. But in short, it's an important point to make at some point during this presentation, because Adam Alter, as Your Honor has probably heard about these social media addiction and influence of teenager cases going on in other parts of the country. That is not how this case is cast. Okay. However, right, they've used an expert from that litigation who has been challenged, which I'm sure Mr. Bohr will get to in his portion of that motion, successfully in part. And so his big thing, right, is that McGee is somehow addicted to this or influenced by this, and she can't really help herself. And SNAP must have known that and wanted teenagers to do crazy things. And that was how they got him engaged. It's some sort of opinion as a conclusion along those lines. And as it relates to addiction or influence or whatever you want to, however you want to phrase that by some psychologist, right, is it ignores the fact, right, that the undisputed testimony is that Miss McGee had never used speed filter before the date of the accident, right? She says that clearly. No one challenges that. None of the witnesses says, oh, yes, she did. I saw her doing it. Nobody says that. There's no testimony that she'd used it before. What's the point? The point is you can't get addicted to heroin until you use it, right? So from a factual standpoint, I point that out now because it'll make sense in the analysis in a minute, right? And so Dr. Bowie, who looked at the metadata in this case, the Blizzard data, that I know your Honor is familiar with, he testified that it showed that he had no opinion that McGee had ever used the speed filter, and it was not reflected in the Blizzard data. And then again, Alter gives this general hindsight opinion about defective feature, but he doesn't link it to any evidence related to Miss McGee. I'll stop and pause on this point just for a second, right? In terms of the second part of the analysis, did the design in the app that is allegedly defective cause what ultimately happened, which is an automobile accident, right? Cause the injury, right? So if it's a blender, it's easy, right? You stick your hand in there, cut your hand. This is much more complex than that, which is why looking at the expert testimony is carefully is so important. But ultimately the question is did it cause that injury, the design defect? And when analyzing Dr. Alter, the thing I would urge and request of the court is that you look at what he did and didn't do. And the thing that bothered me is that he didn't read McGee's deposition. He didn't look at her affidavits. He did no analysis about whether his generalized conclusory opinions have anything to do with Crystal McGee. And for that reason, it has no evidentiary weight that it should be given for purposes of the analysis that we're on right now. Next slide. Okay, so in addition to the fact witness, you got two experts, right? You got Dr. Bowie, which I'll argue later more in detail. He's a professor of computer science. He admits he's never developed a commercially available software application like Snap. He's never done that for smartphones. Other than his phone, no app he's ever, or his students have ever developed has ever gone onto a phone. He's never made one that's been sold to anybody. He's never worked at a software development company since the 1980s, where he worked for a couple of years. He hasn't consulted, trained, or reviewed any training. He has this opinion that they purport he'll give about training at Snap and testing of the products and policies and procedures related to the design of the app. But he's never worked in industry doing that. He's never been consulted by industry in doing that. And he has no experience that's relevant to the standard of care that exists for people at a social media app doing that work. The last time he was a quote software engineer was decades before was a decade before telephones, before he owned a telephone, not just a smartphone, but a telephone like in a bag or whatever the original ones were. He's not qualified, nor has he ever been qualified by any court in the world as an expert on industry standard of care for the design, development, rollout, or maintenance of smartphone applications. He testified to me sort of unbelievably. He's never even seen the Snapchat app work. He doesn't have it on his phone. He's never even seen it. Ever. He admits that his methodology fails. He admits that he did not do a usability study. He says, oh, they should have done a usability study. I was like, would you do a usability study to see what conclusion it would have led to him? No. They should have done a risk-benefit analysis. Well, you saw some evidence that they did analyze the risk because they put a warning on it. Yeah, I did see that. Well, they didn't do a formal risk-benefit analysis. Okay, did you do a formal risk benefit analysis so that you can offer an opinion to the jury from a scientific standpoint that what it would have shown or how it would have led them to a different decision or a more reasonable decision? No. I asked him about the Thong Lee and other Snap software and data engineers affidavits, and he admitted that he had no expert opinion. He couldn't say to a reasonable degree of scientific certainty based on what he'd done in the case up to that point that what they said wasn't true or was incorrect or was misleading. And also concerning, he didn't even read, the plaintiffs didn't even give him all of the Snap testimony in the case to read before reaching whatever conclusions he purportedly reached. Next slide. Right. And so the only opinion, he has, I think, 8 opinions. Opinion 2 is the only one that has any relevance to this portion of my argument related to app design and design defect. Right. And so when I pushed him, right, what is your basis for opinion 2 in this notes or report that plaintiff's counsel provided to me? And the only thing he could point to was a distracted email, an email about distracted driving. And it's true it exists, or run for existing, but it was, as I said, it is a recognition that people could be distracted or use the phone or app when driving, and that's why they put the warning on it. So I'll save this for a little bit later, but he points to these IEEE, which are essentially electrical engineering codes from the 90s, that none of them have any discussion about software, like smartphone applications. But he has no information or knowledge that any of those are used in this industry, were used in this industry, are considered. He just said he teaches on them. And so for the ethics violation that he thinks is there, he points to these 24 depositions, but he says, well, under these ethics codes, you're supposed to, look at the safety of the app. Well, did you do any analysis or any science to see what it would have shown them? No. Did you do anything do you have any knowledge that any software company or social media software application company or anything relevant was using these codes? No. Right. And then, as I said, he comes around ultimately and says, well, they did do something because they reached the conclusion that driving and using the app was bad and put a warning on it. Right. And so importantly, he also goes on to say that he's not a warnings expert, but he never testified. Right. If you take it, this isn't a medical malpractice case and the standard's a little different, but if you take it to that context, right, you got to have a doctor, right, who's practiced the same kind of medicine, right, and can say the standard of care is you don't cut off the right arm when you're supposed to cut off the left arm, right? Just making this a non-controversial, easy example. I know this because I did surgeries on right and left arms, and I'm trained and board certified and blah, 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 blah. And then, right, they got to look at the conduct of the doctor in this case, a software engineer, an executive at this company, a data engineer or data scientist. You got to look at the conduct of those people, having done that ever yourself in your lifetime, right? And then you have to give some opinion that what they did wasn't reasonable in order to meet the burden that's required to prove a design defect, and that they acted negligently with foreseeable knowledge in terms of this software design and engineering, right? And he does not do it. He dances around. The report says some things that we could argue about, but that's not the important part. When he is deposed and he is challenged, he admits that he did not do those things, he has theories about the Blizzard data. He has theories about things. He talks about possibilities. He talks about educated guess. And then but he ultimately agrees he is not giving an opinion about Snap's response, right, to whatever they were getting knowledge about. And that's important. Right? They claim that they had this knowledge that created the foreseeability, but he says he's not giving an opinion about the response to that. And the reason is because he doesn't have one and he's not qualified to do that. Next slide. Right. And so when faced with summary judgment, plaintiffs have the burden to demonstrate a genuine issue of material fact that the product is defectively designed. To do this, they must produce evidence from an expert who is qualified to conduct the risk utility analysis and to opine that the risk inherent in the product's design outweigh the utility or benefit derived from the product. Next slide. All right, let's take a look at their experts and what they testified. Will you agree with me that your statement in opinion two that the SNAP did no risk analysis is false? Since just by virtue of the fact there's a warning, they must have identified the risk, didn't they?
Objection argument.
They didn't do a formal risk analysis, a serious one
Got it. Did you do a formal risk analysis before forming this opinion?
of a SNAP application.
Yes, sir.
No, I did not.
All right. So that's what Dr. Bowie testified to related to whether he did a risk analysis so that he could provide an opinion about the pros and cons or the risk versus the benefits. Didn't do it. Next question. Will you agree with Sorry, next slide. Alter, right? Did you in a scientific way endeavor to list out or determine what from users what the benefit of the speed filter were and utility the speed filter was, and then do an actual business-like or scientific risk benefit analysis in paper or on notes or in writing related to the speed filter? No, that's not part of what I did. Right. And so the standard in the law related to the expert testimony required to survive summary judgment, their experts both admit they did not do. Forgetting qualifications, they just didn't do it. Next slide. Right. And so Dr. Alter, to preview, I'll leave some powder for Paul, but he's a marketing professor and a PhD psychologist. He's not an engineer, design standard of care, and does not meet the criteria for giving an opinion related to design defect in a product liability case. I told you he didn't even read Ms. McGee's testimony, so he doesn't really have any opinions that he can give that have any kind of evidentiary foundation, right, about Crystal McGee and her use of the app and whether it caused this accident. And I asked him in the first 10 minutes of the deposition, Judge, I said, I read your book. I've looked at all this. It looks like you're saying the app made her do it, right? And he testified clearly that it wasn't, he did not have an opinion that the Snapchat app made her do it, right? And that's just a crude way to say, did the app cause her to drive in a manner that caused the accident, right? And Ms. McGee, had he read her testimony, instead of just giving a conclusory response or a generalized response, testified that she chose the speed and the lane of travel and was not influenced by anything or anyone in the car. So it's just a generalized opinions about apps and young people. I mean, he goes so far to say that the statement from Ms. Henderson or Ms. McCarty about trying to get to 100 miles an hour, that creates that based on some prior literature that says humans like round numbers, that's probably motivating to have a 100-mile-an-hour goal. Those articles have nothing to do with software application. It has nothing to do with the design of an app. And I point that out only at this point to point out that his opinions are not scientifically credible or accepted as it relates to the standard for design defect from a software engineer. He doesn't set a standard of care in the industry because he's not qualified to. He's not familiar with it. He only offers the hindsight conclusory opinions. As you saw, he didn't perform a risk benefit analysis. He's not qualified to do one anyway. And he doesn't support his opinions with any kind of scientific study of drivers or any kind of publications showing that the use of these apps or the influence of these apps cause drivers to get in more accidents or cause more accidents. And that's important on some level because as sort of a preliminary starting point, right, for the causation portion of this, you'd want to know, well, you start with the proposition. Teenagers have been recklessly driving automobiles since automobiles were available to teenagers. Okay. And so if one wanted to do a scientific study, and I'm not saying this is the only way, but I'm just giving one example, one might look to see whether or not the advent of smartphones, or specifically the speed filter, if you wanted to do a scientific study, right, of that, you could look at the number of accidents, which the National Highway and Safety Traffic Board publishes. You look at the number of accidents involving an age range of people, right, before smartphones. You could look at that period. You could look at that group of accidents that happened when the speed filter was rolled out and while it existed. And you could look then after the speed filter was removed from the app, you could look and see if the number of accidents went down. Again, not the only way to do it, but that would be one methodology that one might employ to see if the speed filter actually increased in any scientific or meaningful or statistically probable way, making it more likely than not it was the cause. That's how an expert could go about and analyze that. I asked Dr. Alter about it. He's familiar with cohort studies. He's done psychological studies of some sort, just not here. And he didn't do anything scientific to answer the question of, does the speed filter cause more accidents or not? And he didn't do it in a general or a specific way. All right, next. And he has no specific causation opinion, right? So in toxic torque and drug and device and other cases, specific causation is like, does asbestos cause mesothelioma? That's a general answer. The answer is yes. Specific is, did it cause so-and-so's mesothelioma, right? The plaintiff in the case. That's not exactly the analysis here, I will concede. But there is a specific causation element that is required to survive summary judgment under proximate causation. What is that? Right? I actually looked at the testimony of the person who is alleged to have, the design of the app is alleged to have affected. You would think at least a prerequisite would be to read the testimony of that person and know something about that person and their use of the app. And he had none of that information in giving this opinion by way of foundation. That is not something that the court should just brush over and say, oh, that goes to weight, not admissibility, right? The standard is, do they have the evidentiary basis for their opinions? Was the methodology they employed when they looked at those facts, was it scientific in nature, or is it just conclusory? That's a gatekeeping function that is incredibly important in a case like this. Next slide. All right. If we, this is a brief example of things he might have learned had he taken the time to review Ms. McGee's testimony.
2013 to 2015 time period was a little before the rise of Instagram in terms of use, and maybe even before the direct messaging and stuff on that app. So did you, it sounds like you use Facebook for posting and Snapchat more for communicating?
Yeah, and periodically I would do a story picture on my story, but usually I just messaged people and used it for like a text messaging platform.
Another stupid question, but I gotta ask, okay?
No problem.
I'm assuming that you didn't receive any kind of financial incentive or store credit or any kind of monetary gain for communicating with your friends on Snapchat versus some other way, right?
No.
All right. I mean, other than it was easy and your friends were on there, was there any kind of incentive in your mind to using Snapchat to communicate with your friends?
No.
What about for posting?
No.
Did Instagram or Facebook control your behavior, whether driving a car or otherwise?
No.
Did anybody, like family members or friends, tell you that you had a social media problem and you were doing dumb stuff so you could post it on the internet at any point during that period of time before this accident?
No, never.
Did you ever do anything that, looking back, you think is dumb, right, just so you could have some social media content?
No.
That's just a portion of the totality of her testimony. But at the end of the day, right, how the particular person uses it, and the influence, I guess, if that's the allegation that it has on that person, is something that the expert ought to explore before they just reach a generalized conclusion. And that did not occur here. Next slide.
2013. All right, and then this is more testimony from McGee. I won't read it into the record. It's found in her deposition, but in short, right, there's additional testimony you could have considered, right? So in terms of speeding, right, well, I asked her directly. Essentially, the articles, because as Your Honor will recall, there were some news articles that came out after about 8 months after this accident about her use of the speed filter. There was a defamation suit that was dismissed on anti-slap. There's lots of briefing on that I won't repeat at this stage, but I'm asking her about these articles, right? And essentially the articles that are saying that, you cared more about social media or Snapchat than human beings' life. Is that true? That's not true. In terms of speeding, whether it's going 60 in a 55, 65 or 70 in a 55, whatever it is, and I'm not suggesting the speed you were going. I'm just saying if you go over the speed limit, you knew that could cause you to get a citation before you got in the car that night. Yes. And you knew that you weren't supposed to be looking on your phone or be distracted by your telephone, whatever app you got, because you got in the car that night before you got in the car that night. Right. Right. And so the testimony from the witness, which is undisputed, is that she knows, right, that what the hazard is. She knows she's not supposed to do that. She also denies doing it, but because there is fact witness testimony saying she did it at this point, right, that there is a conflict in the evidence for a jury on that point. However, her motivations and how often she used it and how it affected her and what her family members thought about that and whether she knew right from wrong and made the decision, as I showed you earlier, what speed she was going, or to look at her app if you accept that that's what she was doing. Those were her decisions alone. And there's no conflict in that, except for the only conflict presented in evidence by these folks is that this expert who says, well, teenagers are more susceptible to social media, right? Teenagers are, that this speed filter psychologically makes people want to go 100 miles an hour because people like round numbers. Right. And those are generalized opinions, right, that do not apply to Crystal McGee. Next slide. So one of the things that needs to be established by expert evidence is the standard of care, the industry standard that applies to social media app development, or at least application development for a smartphone. To be apples and apples, right? And so I asked him, do you agree with me that currently there is no ethics standard or oath that would be considered industry standard for tech and social media app development? And he says, I'm not sure what the personnel at these companies discuss behind closed doors, but I don't know of an industry standard. So he admits that in terms of these ethics things that Dr. Bowie suggests, his experience with the social media companies is there is no industry standard, and he certainly can't articulate one as a result. Next slide. All right. So their experts didn't do a risk benefit analysis to scientifically support a conclusion of what it would have shown, or that it would have been more reasonable to reach a different conclusion. There's no opinion with a basis in admissible evidence what studies or testing that the SNAP should have done to be more reasonable in 2013, or if they did them, as they complained they didn't do, would have reasonably led to X, Y, or Z in terms of a different design. There's a bunch of, at the end of the day, what they have is there's a bunch of accidents later, not a bunch, there's a handful of accidents later, right? And so how could you not conclude that injuries to people outweighs utility?
right, of engaging people and people being able to express themselves. I got it. I understand their argument, but you can't say because something bad happened 5 years later after you made the decision, that should have informed your decision 5 years prior, right? And that's essentially what Adam Alter does. It's hindsight bias, and it has no place in this courtroom. And it's certainly prejudicial if it's allowed. And so when an expert gives a general opinion, right, under the guise of being an expert, whether it's in computer science, a professor who's been a professor for 30 years, or it's a guy who writes books and goes on talk shows and podcasts and talks about, you know, the evils of social media applications. When an expert gives a general opinion without applying it to these people, in this case, it's even more prejudicial. And lastly, and most importantly, they admit, right, under a design defect, negligence, and risk benefit analysis that they don't define a standard of care or describe based on the evidence how it was breached. There's 3 instances of SNAP testimony about it to begin with, and 2, they don't provide any basis for their opinion otherwise. So they're generalized and they fail to meet the standard that is needed in order to survive summary judgment. They don't define the standard of care. There's none of them, all of them agree they're not warnings experts, and they haven't done an analysis that rightfully would lead to that conclusion. Next slide. All right, we'll play this.
All right, and you were asked some questions about whether or not you were asking about what it says in the answer to the first complaint that I think has been amended a couple or 3 times after that. All I want to know is all of the decisions you made in terms of which lane you were in, what speed you were going, those were all your decisions, right?
They were all my decisions.
They weren't influenced by any person in the car or anything in the car, correct?
Correct.
Okay.
Next slide. Okay, I'm getting close to the end.
I was I was just trying to time a break, so.
I mean, I'm happy to take one now, or
How much time do you think you have left?
I-
And I don't want to
one
rush you,
moment.
because again.
I don't
this
think
is-
very long. Enough that it's not 5 minutes.
Okay, let's take a quick break. We've been at this for an hour and a half, so I try to take a break about every hour. So hour and a half is my max limit. So, all right, everybody, just long enough to step to the restrooms. I told you where they are, and then we'll come back in the session when everybody's back here.
Thank you.
All right, let's go back on record. We have everybody here. So Mr. Maston, I'll give you back the floor.
I forgot that at the back of my PowerPoint there is also the buoy motion. So I might have been able to do it in 5 minutes, but I've learned not to overpromise about time. I always fail. When we left off, we'd gone through sort of the legal analysis and what the experts, what Snap's testimony was, et cetera. The thing I should note for the record in the court, Judge, I think, and by agreement, Naveen and I talked about this, we have tried, whether appreciated or not, I guess, I can certainly understand, but we've tried to file every deposition that's been taken. Okay.
It is greatly appreciated.
And I know there's tons of, and all the exhibits. So I know that makes up a lot of pages, but we wanted the record to be complete. There's a possibility that there's a couple of exhibits that are missing here and there that we are working together to supplement. And there's some correspondence that we don't need to bother the court with yet, but some things that, were identified in a deposition and haven't been produced yet or haven't been produced in whole. In any event, the point being is, I'm sure both the parties, or all the parties, I should say, if there's anything you're going through the review of this evidence that seems to be missing, it's not on purpose. It's accidental, and we'll be happy to provide it.
Thank you.
Okay. So,
and again, hear me say to both of y'all, that to all of you, that y'all filing the transcripts is very helpful, because again, I'll have a thought, I'll go look for something, and I'm very grateful to have all those and the exhibits at my fingertips.
thank you, Your Honor. And so, for a second, I want to turn to what doesn't create a question of fact. Okay. In their response papers, the plaintiffs point to the McGee phone spoliation issue as a reason the court can't grant summary judgment. All right. And so, first of all, right, as it relates to, from Mr. Maynard's standpoint, could he have avoided her negligence by not crossing 2 lanes of traffic or not pulling out to begin with? The phone doesn't have anything to do with that. Maybe we'll hear something different, but I don't think there's anything on the phone supporting or refuting Mr. Maynard's ability to avoid the accident. I don't think there's anything on the phone supporting the negligent design claim. Now, they might argue that there's something on the phone that would, support that she was using Snapchat, as they have obviously disputed, but I don't think that would go to Snap's knowledge, foreseeability, and those type of things. The user data, as Your Honor recall, was produced in this case for many years for each of the occupants. On that point, I should say this for the record. There seems to be some, throughout all of this briefing, this is more of a generalized thing, but throughout all this briefing, there seems to be this thread, with the experts, that they didn't get source code, as an example. They didn't get, the Blizzard data or the server side data, so that the reason they don't have opinions is because of various excuses. And the thing that I want to point out is that at no time, right, we did go back and forth informally, and I think formally on the record, about the production of Blizzard data, the associated costs with doing so, how it works, right? We set a protocol for pulling the data from certain years, because Your Honor may recall, all of that Blizzard data is on the server side. It's not assigned to users. It's just massive piles of it, right? And the Blizzard data pulls out the user data, right, for the discrete user. And at no point have they filed some subsequent motion to compel. Have they asked for source code over a decade after going to California? Well, maybe not after a decade, around a decade after going to California and meeting with those software designers and engineers and getting the initial Blizzard data. The first time they asked for source code was many years later, and Your Honor has ruled on that in that discovery response. They also seem to complain a lot about some sort of, they call it a black box I think I was accused of all manner of sorcery in their briefing. But the bottom line is that the Blizzard protocol, which they argue is not perfect, it's not like there is some allegation or finding by the court that Snap didn't go do what the court ordered them to do related to the Blizzard and the data in the form of an order. And I say that because it relates really to all of these motions, and it occurred to me on the break. And so some absence of something that wasn't asked for in discovery doesn't create a question of fact, being the point here. Also, the phone issue, right? So the court knows this, but sanctions for a spoliation cannot be applied against a party who did not destroy the evidence when there is no evidence to show that the destroying party was acting at the behest of the other party. It's undisputed that the control of the phone was in McGee, her family, or her lawyers, and not Snap's. And so the plaintiffs invite the court, I guess, to make error, because if the spoliation sanction is used, then that is a affirmative punishing or sanction of Snap to lose summary judgment because something not in their control occurred by a different party. And we certainly didn't, there's no evidence, nor did we being Snap, request her to not preserve her phone. This is undisputed. If there's any question about it, I've attached a June 12 of 2017 affidavit, right, where she agrees that she previously had invoked her Fifth Amendment right, but that she she had invoked her Fifth Amendment right, and here she's revoking it. And look at the date, right? June of 2017, right? And will allow her cell phone to be examined. Why that didn't occur until whenever it was requested again is not Snap's doing. Next slide. Right. And then I asked Ms. McGee about, this is from page 81 and 82 of her deposition, right? I mean, she confirms that she had her phone. She got a letter from plaintiff's counsel that forms the basis of their spoliation. She continued to use her phone in September, October, November, December, January, February, March. I go on to ask her later, continuing April, May, June. In all that period of time, she has the phone. It's in her control, not Snap's. Did you do anything to cause anything to be deleted relevant to the matter? No, I didn't. I didn't tamper with anything on the phone or delete anything. I won't revisit the sanction motion at this point, but I will say that to the extent that the plaintiffs now urge the court to hold this against Snap on their grounds for summary judgment, it both doesn't apply, nor would it be appropriate as the non-spoliating party to be so punished. Next slide. Okay, so before I get to these last two things, as I said, the court has all the depositions and all the exhibits in the record. Obviously, there's exhibits to these motions on top of that. But ultimately, the facts that are needed related to the first question of avoidable consequences are I've been through today, and looking at evidence beyond that are disputes about the use of the speed filter do not have anything to do with the analysis of avoidable consequences, because it assumes necessarily negligence on the part of the other parties. On the foreseeability and the design defect, the plaintiffs in their response brief, and I assume will argue here, oh, well, a jury could figure it out. A jury can do a risk-benefit analysis. The specialized knowledge to write the code, design, release, roll out, get it to go from, even the miracle of getting something to go from a server onto someone's telephone through the air is remarkable to me, right? This is not, I reviewed the policies and procedures and they were supposed to inspect and they didn't inspect. I looked at the witness testimony and it was a green light, and everybody said it was a green light instead of red light, and that person, had the right of way. It is not an ordinary negligence standard here. And so the idea that a jury should be allowed at this gatekeeping moment, right, to consider all of this and make a decision about the very technical design the testing that is appropriate in the industry in 2013, that was customary in the industry, and then without any scientific explanation related to the facts of how they breached that standard of care, is not what the law requires. And so the idea, let's leave it to the jury, I would submit to the court, is the wrong one. For the reasons that we've been through, there's a derivative claim for a consortium. Obviously, if the primary claims fail as a matter of law, the derivative claim does also. That's all the time I'll spend on that because I'm sure the court is familiar with that. Next, or last, there's 2 counts that I need to briefly address. One is punitive damages. The experts do not offer opinions supporting the standard for punitive damages. The evidence from SNAP's witnesses does not rise to that level. And we would submit that allowing the jury to determine that as the facts exist to SNAP anyway, it doesn't rise to that level. So we'd move, in addition to everything else, we'd at least move for partial summary judgment on their punitive claim. Next slide. Attorney fee claim is the last. I think it's under 13,611. I'm not looking at it, but I think that's what it is. Your Honor may recall one of your earlier acts in this case was to look at a motion for frivolous litigation filed by SNAP. And I think if nothing else, at that point in the litigation and until today, right, the parties' positions are clear, right? I mean, there's things for the court to decide. There may be things outside of what we've moved on that a jury could decide related to Miss McGee and otherwise, but to suggest that the parties have not been advancing, judiciable law and facts, I think would fly in the face of what Your Honor and the court knows from our conferences, formal and informal, and the positions of the party. So we'd move in the absence of such evidence that the attorney fee claim also be dismissed. So, Judge, I think that, is there any other slides? Oh yeah, so that count 3 is just the litigation expenses. It is 13,611. Next slide. Oh, good. All right, so I'm out of slides, and I appreciate the court allowing us to set forth our basis for the summary judgment. Before I sit down, any questions, anything I can address for the court?
No, so you're looking for the whole thing. If I don't give you the whole thing, you're looking for punitives and attorney's fees. Is there any other way, short of what you want in whole, that you want me to consider slicing and dicing your request?
That's a great question. And I'll do the best I can. So on so there's 5 categories or five things that we're moving on, and I'll do them in reverse order. So the derivative claim fails if the main claim fails. That I don't think that you're right. Yes, we would like for you to dismiss the fee claim and the punitive claim based on a lack of evidence in the record. And then breaking out the other 2, right? The court's determination may be affected by the Daubert motions, or the 702 motions, I should say, that are to follow today. But yes, I think in that instance, we believe that they failed to meet the standard as I articulated or tried to earlier. And then on the avoidable consequences, that one probably could be broken out. I'm not suggesting it should be. I'm just saying it could be broken out in that they've made affirmative allegations or contentions that Mr. Maynard has no negligence, right? And so that would be contributory negligence, I suppose, in this scenario. The evidence is undisputed that he plays a role, if nothing else. And so theoretically, summary judgment could be granted as to those claims without summary judgment being granted to the doctrine of avoidable consequences. But I'm not exactly sure how, because they're pretty closely tied together. However, you could have a situation under a set of facts, not these, but a different set of facts, where contributory negligence was established as a matter of law, but the doctrine of avoidable consequences was not, right? So as we stand here now, and I'll anxiously await what the evidence that is now the plaintiff's burden to present to defeat summary judgment will be why or what from Mr. Maynard's standpoint, he couldn't have done to avoid it or didn't have the knowledge to avoid by crossing those two lanes. But I think those things dove together. So coming back to your original question, yes, I think we're asking for total summary judgment related to those issues surrounding crossing two lanes of traffic without yielding to oncoming traffic when their expert says that the accident wouldn't have occurred, right? That sort of brings causation into play without him doing so. So those are our arguments, I think, at this point, Your Honor.
Okay, thank you very much.
Thank you, Judge. Judge, before Naveen starts, can I just hand up a paper copy of the presentation?
That'd be great. Thank you.
Thank you.
Ready when you are.
Good morning, Your Honor. I want to start by just remembering how far we've come. It's been 10 years since I first argued this case, and I believe that Your Honor was not officially an honor. You were here after you'd been appointed and were about to start.
Yeah, I'd won, almost there. I'd won the election and was waiting
better.
for Judge Essery to retire.
Yeah, and I go back to that moment because even then, we had an important piece of evidence that needs to be kept in mind when we're considering summary judgment. And then that's the affidavit from Heather McCarty. And I want to read it for a second because we heard a lot of clips from Miss McGee about how she wasn't influenced by Snapchat, wasn't using Snapchat. And if this were in front of a jury, if we had that box full, they'd make a decision on that. But this is what Miss McCarty said. Quote, I asked Crystal if her phone was keeping up with the speed of the car. Crystal said it was. I told her I was pregnant and asked her to slow down. Crystal responded and said she was just trying to get the car to 100 miles per hour to post it on Snapchat. She said, I'm about to post it. So all this testimony from Miss McGee about how, she wasn't influenced, it didn't make her do these things. That's great. You can put that in front of a jury, but for summary judgment purposes, Your Honor has to accept Ms. McCarty's testimony is true. So not only was she speeding, not only was she using Snapchat, not only was she using the speed filter, but the reason she was speeding, the reason she was going 100 miles per hour is because she was trying to get the car to post it on Snapchat. She said, I'm about to post it. I think we've got a great preview of what the cross-examination of Dr. Alter will be. It will be, well, should we believe Ms. McGee or Ms. McCarty? But those are issues for the jury to decide. And that's going to be a continual theme throughout my argument here today about the influence of certain testimony that they've isolated versus the testimony of the case as a whole. So that's point number one that I want to make as a general part of this analysis. And it responds to what you heard from opposing counsel about what he identified as two fallacies. One was about the summary judgment standard. Well, the summary judgment standard tells us that we don't get to pick and choose between what witnesses we believe, and that's for the jury to decide. And then the second one is this idea that we have come into court saying, well, because we defeated Snap's arguments on appeal, that therefore we necessarily win summary judgment. That's not what we said. It's not even remotely what we said. What we said in our summary judgment response, as Your Honor has probably read and I'm sure review again, is that many of the arguments that Snap has made have been rejected, and those arguments should sort of be cleared away. And I'll give you a perfect example. I heard opposing counsel say that there's no, quote, no foreseeable risk of intended use of the speed filter. That's not the standard. We already litigated. We litigated that before Your Honor to the Court of Appeals and the Supreme Court. And the Supreme Court said it's not, the question is not whether it was intended or not, it's whether it's foreseeable or not. And there's no heightened standard when it comes to foreseeability. I heard opposing counsel say that we have to show that it was intentionally weaponized. That's not, that's, frankly, that's the phrase that Mr. Masterson came up with. It's not in the Georgia Supreme Court opinion. If it were, we would have seen it. You would have seen it in the briefs. The question is just foreseeability. And so that's why we talk about those Court of Appeals opinions, Supreme Court opinion and Court of Appeals opinion. And there's one part of the Court of Appeals opinion that's really, really important here. And why I read that testimony from Heather McCarty, the Court of Appeals relied on that testimony specifically to say that that testimony establishes causation. And it was an odd situation because it was on a motion to dismiss, but we already had that affidavit. That's why I went back to the 10 years ago when Your Honor wasn't Your Honor and I was a fifth-year associate at my firm, because that's how long we've been waiting to put Crystal up on the stand, to put Heather up on the stand and to see what happens. I heard this phrase from Judge Jordan in Cherokee State. I don't know if you know him at all, but he's been, I think he's 25 years in and he's about to finish it up. And he always uses this phrase, you've got a good arguer over here, you've got a good arguer over there. And we have jury trials for a reason, so that these great lawyers, trial lawyers can get in front of them and make the case, and then the jury will decide. We all have ideas about what they might do with that, but this is what we've all been waiting for the last decade, is for this moment. All right, so that's my general outlook, and then I'm just going to go right through each of the elements. I'll try to give you some signposting along the way so you understand what issue I'm dealing with specifically, but it's generally going to follow what we said in the brief. So let's start with issue number 1, which is the SNAP's argument about avoidable consequences. They are basically saying here that Mr. Maynard was, number 1, negligent, and number 2, that he was the sole proximate cause of his injuries, that there was nobody else, just him. So in order to do that, they have to prove 2 things. First, they have to prove that Mr. Maynard had reasonable knowledge that he knew of the danger, because that's required in order to have avoidance. And then second, that he reasonably could have avoided the danger. So have to have knowledge of it, and then second, you have to have the ability to avoid it. And in a rear end collision case, that's an extremely high burden to establish. We've cited opinions from the Georgia Supreme Court that indicate that, and Your Honor knows it just because you've had, I know because I've been in front of you in these types of motor vehicle wreck cases. These are the quintessential fact disputes that we have. So let's start with whether Mr. Maynard was negligent. And there are 2 aspects to that. First is, what did he understand and what did he do? I'm going to start with what did he understand. The most telling thing that I heard from opposing counsel during this initial argument about whether Mr. Maynard was negligent is the assertion that SNAP's already established their affirmative case for their defense. That's not true. There is absolutely no evidence that Mr. Maynard did appreciate or should have appreciated the speed at which Crystal McGee was driving her car. There's nothing on that. So this idea that, well, he's got half a mile line of sight, he would have seen Crystal. Okay, let's assume that's true. Let's assume he sees her. What does that tell us? Does that tell us anything about the speed? And it doesn't. And we cited this testimony in our briefs, but our expert, Sean Alexander, the reconstruction expert, explains that most people, when they see a car, can't visually identify its speed. It's just simply not something that happens because our brain doesn't work that way. It's not something that you can just figure out on your own. And I'll give you a personal example to help bring it home. I'm a bicyclist. I bicycled this morning, over the weekend. Did a lot of it on the Beltline, and there's a long stretch of the Beltline where it's just open road. Very well, it's not half a mile, but it's pretty significant. And this thing keeps happening to me over and over. I'm going along, I see somebody in front of me, maybe like 400 yards, even more, with a dog, and they're about to cross the path. They turn, they see me coming, And then they just keep going. And the reason they keep going is you're not expecting a bicyclist to be going 25 miles per hour. But that's how fast I was going. Because in their head, one, they're just not able to calculate. It's just a human reaction. And two, they have a preset of what they expect a bicyclist to be doing. Most people expect bicyclists to be going 10, 15 miles per hour. They're not thinking about, the Lance Armstrong people who are in spandex going crazy fast. It happens over and over and over. They see me and they don't appreciate the speed. And that's exactly the kind of thing that a jury can find in this case. The defendant's snap cites the fact that Mr. Maynard frequently turned out at this intersection, so he should be familiar with it. Great. He's familiar with people driving within the speed limit. And from that expectation, the jury can find that he sees the car and he believes he has enough time to change lanes because he's not expecting someone to go 90 to 100 miles per hour. He's expecting someone to go the speed limit. And that's exactly what our expert said in this case. Sean Alexander used an example. We quote it right in the beginning of our brief that if you have, he's talking about himself, I think he said, look, every day I back out, there's not a problem. I have a reasonable expectation to believe that everybody's following the rules of the road. Now, one day I back out, I got plenty of time. I back out, I get hit. I'm like, what in the world? That car's 30 miles an hour over the speed limit. Well, did I really fail to yield? Was she close enough to be a hazard? That's what the jury has to decide. It's that simple. There's no evidence, absolutely no evidence from Snap that says that Mr. Maynard should have been able to appreciate, that anyone in that position would appreciate that she was going that speed. That alone defeats this motion. It's that simple. If you don't have an appreciation of the danger, you can't be held liable under the, you can't be held to have no claim under the avoidable consequences doctrine. That's number one. Number two is, like I said, they've got to, when we're asking about whether Mr. Maynard was negligent, it's what did he reasonably understand and then what did he reasonably do? So they said, and pointed to the testimony, that he just came out into the left lane. That's not what the testimony unequivocally establishes. It establishes instead, what the jury can find is that he enters the right lane and then goes into the left lane. And there's a couple of places where we see that. The first is in, let me get it exactly right. Sean Alexander's testimony, quote, where he's referring to Wentworth, Mr. Maynard got the 14.9 miles per hour. It's as if he's just coming out of that curve and he's slowing down. I can tell you slowed down the area, and that may be consistent with somebody checking. Now, I agree. He also says it may not be consistent with somebody checking because he doesn't know. Again, that's what juries decide. The juries decide whether the behavior that Mr. Maynard was doing, so he's slowing down before he enters into that left lane, whether that's consistent with somebody checking or not. For a jury, they don't have any evidence that says otherwise. It's something that the jury has to decide. We also have Heather McCarty's testimony. She was asked, question, did he pull directly into the left lane? Answer, no. I mean, he made his way over. Question, so some time passed from the time he first turned onto Terre Boulevard. Answer, not much time, but yeah. So again, not an immediate straight into the left lane, but enough evidence for a jury to conclude that he slowed down, that he looked, and then the question becomes, okay, well, what should he have understood at that point? That's all there is to this. That goes to the jury. So the second part of this is the question of whether Mr. Maynard is the sole proximate cause. So first part, like I said, is was he negligent? Jury can find he wasn't, either because he did look, or because even if he had looked and saw what he saw, he wouldn't have appreciated how fast he was going. And that's enough to defeat this claim. And then the second part is he's not the sole proximate cause. So Snap says, well, the wreck doesn't happen if Mr. Maynard doesn't change lanes. So there's two ways of thinking about this. We first look at the expert testimony, and I'll just give you an example that I came up while I was avoiding people on the Beltline with dogs. So the expert testimony that they point to from Mr. Alexander is the wreck doesn't happen if he's not in the left lane. I don't know if you heard it in his voice. I definitely could hear it. When you ask an engineer a question like that, would the wreck have happened if he's in the right lane? Well, yes, as a matter of physics, he says, if two objects are not in the same space, they can't collide. That's great. That's like, a butterfly flapping its wings and affecting change somewhere else. That's actual causation, not proximate cause. So the question is not whether if he had not been in the left lane, the wreck wouldn't happen. The question is if McGee had used ordinary care, would this wreck have occurred? And the answer is no. So Mr. Alexander also says this wreck doesn't happen if the car, he's referring to Miss McGee's car, is 270 feet further back, which is the distance, and it's maybe technically 265, that would have, if she was going the speed limit at 55, that's where the car would have been when Mr. Maynard entered the left lane. So right there, we know the wreck doesn't happen if McGee does not act negligently as contributed to by Snapchat. And he totals it and says that with the additional 265, 270, she has 673 total feet. So she has enough time to brake, move into the right lane, and avoid this collision. That's what the jury decides, whether that would have made a difference, who's at fault. Those are all decisions for the jury. But the mere idea that because he changed into the left lane, that alone means that the wreck wouldn't have happened if he wouldn't have done that, you'd clear your docket of so many motor vehicle wreck cases if that were the rule. If all you had to prove was that physically the injury wouldn't happen, or even if you could just prove that there was some negligence on the plaintiff, that the defendant would get summary judgment, again, you would clear a docket of most motor vehicle wreck cases. The rule is not if the plaintiff is negligent, that therefore the defendant is not. That's why I have comparative fault and other situations like that. So the example that I came up with, I was thinking about, and I really do say this in jest, but I do want to just use this example. If Mr. Neff punches Mr. Masterson in the face, and Mr. Masterson says, "What are you doing?" And Mr. Neff says, "Well, why was your face there? Why weren't you somewhere else?" That would be absurd. Obviously, we would say Mr. Neff is at fault for punching him in the face. These are the types of logical questions that we're raising when we say things like, well, if his car wasn't in the left lane, it wouldn't have made a difference. Yeah, obviously. But the question is whether he should have appreciated how fast she was going, or like every other time he left his apartment complex, saw a car in the distance and thought, well, they're going the speed limit, I have enough time. And instead, she's going 100 miles per hour. Even the testimony that they played from Miss McGee backs us up. Mr. Neff kept poking me when she was saying this. She says basically in a second he was there. Well, yeah, because you're going 100 miles per hour. That's why it seems so fast. That's why we have these laws, for many reasons, against speeding of that extreme, is because your reaction time is not nearly what it would have been otherwise. Those are the questions that a jury has to decide. Last thing I want to say about this avoidable consequences doctrine is I want to address the Weston versus Dunn case. So first, it's not a rear end collision case. I think it's a head on collision case. And the important facts that exist in that case is the decedent knew that her vision was blocked. So she comes up on an intersection. There is another truck, I guess it's basically the Dunn truck that is in front of her. She knows her vision is blocked. And instead of going around, so she had another option to go around it, she goes to the other side where she also from experience knew that there were logging trucks that go over the speed limit and just went right into it. And that's how she was hit and killed. We don't have those facts in this case. There is no evidence that Mr. Maynard appreciated how fast she was going. There is no evidence that he knew that his vision was blocked and decided to test it anyway. None of that evidence exists in this case. This is nothing like the Weston facts. And I think even opposing counsel recognizes that when we're talking about the uniqueness of that. I mean, it's a rare case that happens, and it's not the case that we have in front of us today. All right, so unless there are any other questions, I'm going to move on to the foreseeability question.
We're ready.
So the foreseeability part of the case comes in on many places, but it primarily comes on the question of duty in a price liability case. So there's going to be some overlap with some of the other issues with design defect, but what I'm really talking about just here, or trying to talk about, is why Snap knew or should have known, a jury could find, that Snap knew or should have known that the speed filter would be used in this way. And if that's the case, then they have this duty to guard against that danger. And I'll talk about that on design defect. All right, so foreseeability. I'm going to get to the evidence in a second, but I want to sort of set the table on the legal standard. So first thing, and we know this from the Maynard Supreme Court opinion, foreseeability does not mean more likely than not. I think I heard opposing counsel use the reference about whether Dr. Alter and Dr. Bowie had satisfied the more likely than not standard. That's not what foreseeability means. And so to the extent that that's what they were saying, that's not what it is. The language from the Maynard opinion is, quote, such a chance of harm as would induce a prudent person not to run the risk. That's the standard. What a reasonable person, a prudent person think, this is not a risk we should take. And one of the things that Dr. Alter talks about, which I'll talk about more later, is he says, I mean, he's doing the risk and utility analysis. What is the benefit of this versus what is the risk? And he uses it as an example. Okay, well, we take risk when it comes to airplanes because flight is an important and essential service in a global society that we live in. And so we can accept some of those dangers. None of that exists with the speed filter. So anyway, I'll get more to that when I get to the design defect. So that legal point number one, foreseeability is not more likely than not. It's a chance of harm that a prudent person wouldn't run the risk, and you don't need to do anything more than look to the Maynard opinion to establish that. Point number two, foreseeability depends on the totality of the circumstances. There is no requirement, for example, that there be a prior speed filter incident. You look to all the evidence, and that is established in the CVS versus Carmichael case that came out 3 years ago now, 2023. And the Maynard case also supports that. Now, in the reply brief, which we got on Friday, and so may not have fully digested yet, Snap argues, well, those cases are about premises liability and they don't apply to a case like this, like a products case. We know that's not true for a couple of reasons. First, in the Maynard case, in Justice Colvin's majority opinion, she says, quote, as in other areas of law, foreseeability is generally for the jury. And then she quotes a premises case. So the idea that premises is somehow different doesn't make any sense. And I also believe it was either on the opposing counsel's PowerPoint or in the reply brief, they themselves cite to cases that aren't from products liability. So there's Monroe versus Universal Health. That is a negligent hiring case. They use the same foreseeability analysis that we're talking about here. The Stringer case is a motor carrier. I think it's like a MARTA type case, not a MARTA case, but a motor carrier case. Any event, point being, there's absolutely nothing that suggests that those principles don't apply here. More importantly, the overall thrust of the Supreme Court opinion in Maynard is that we don't have these bright line, hard and fast rules that say, okay, you can only have some type of evidence for foreseeability and not other kinds of evidence.
What was that Stringer site? You got a little ahead of me. I was with you on Monroe. I pulled that one up.
Yeah, and to be honest, I don't have it because it was a case cited by Snap.
That's all right.
It's a Southeastern versus Stringer, I think. Do you guys know what I'm talking about?
Stringer sounds right.
Yeah, I definitely heard you say Stringer.
I'll find it.
Okay. We took it out of the Maynard opinion.
Yeah, I'll find it. We're
Okay.
good. I have all the rest of them. So I just went, I was with you until you said Stringer and then I lost the thread.
Yeah.
So 304. Appeals 84. Got it. All right, we're good to go.
Can I read into the record, Your Honor?
Yes.
Weston v. Dunn, D-U-N, Transportation and Stringer, Inc.
Yeah.
Is that it?
I was actually referring to a different case.
Excuse me.
That's the Weston case.
Yeah, I was referring to.
I'll find it.
Yeah. Well,
I'm pretty good at this. Like I said, I was tracking you without citations and then I lost it.
yeah. Well, that happens. As Mr. Bohr said, it's one of the cases cited in the Maynard Supreme Court opinion, and the point simply is that that's not a products case. And that's just a confirmation that the same foreseeability principles from other areas of law apply here. Legal point number 3, opposing counsel made a point of emphasis that you have to look to 2012, 2013. That's not true because this product is not like, I forgot the example, like a wood chipper or a blender. where you sell it and then it's out of control of the manufacturer. Snap continuously updates their product. So if they learn anything between the time that they released the product and the time of the incident, so 2015 in this case, September 2015, that's all relevant to knowledge. There's no principle of law nor any practical reason that you would say, oh, well, we learned about it in, let's say, March of 2015, that we couldn't have stopped the speed filter at that point. We know they can. All they have to do is make a small code change, and that changes how the product works. So we're not limited. There's no way that the jury is limited to only 2012, 2013, although there's evidence of that as well. So those are my three sort of legal points about foreseeability. First, it's not more likely than not. Second, it's totality of the circumstance. Don't have to have a prior incident. And then third, we go all the way to the incident date in terms of their knowledge. All right, so now let's talk about the evidence. We listed it in our brief. There's 7 types of evidence. I'm going to quickly hit through them. Number 1, and this is in the 2013 range, November 29th, 2013, Micah Schaefer emails Evan Spiegel and says, the subject is speedometer. And then the body says, make sure we display a warning about not using while driving. Not distracted, not the weather app, but the speedometer itself, which is the speed filter. So even before they've decided to actually release this, they already recognize that this is a risk. And that's why they're telling, why Mr. Schaefer is telling Mr. Spiegel, we got to have this warning. And Dr. Alter expands upon this, and we'll get into this more when we talk about the Alter motion, but he's explaining that based on his industry knowledge and about how you interpret risk, how you should interpret risk as a designer of software, that's a big red flag that you've got an issue that you need to address. Number 2, December 20th, 2013, so just a couple of weeks later, when the speed filter is actually announced, Evan Spiegel tells The Verge, an online publication, quote, don't snap and drive. So yet again, they recognize that that risk exists. So important that on the very launch of the product, they're telling people that this is an issue. Third, we have the change.org petitions. There's 2 of them. And they, for example, mention, quote, allowing users to see how fast they're moving when Snapchatting encourages them to use the app while driving. So again, you have this warning from the public, essentially. Now, their response has been, well, there's no evidence that Snap ever got those change.org petitions. But this is from their 30B6, I don't know how to pronounce his name totally, Kaditz Peck. Quote, any mention of Snapchat would come to us. This is what you do. As a modern technology company, you scour the internets for any mentions. And that's exactly what a jury can find, is that, quote, any mention of Snapchat would come to us. It's for a jury to decide whether they actually got this, should have gotten it, and what they should have done with it. Number 4, and I used the March 2015 data for a reason. In March 2015, there was a request from a Norwegian reporter that obviously made it to Snap, because that's how we got this, quotation. The concern is that this leads people to taking selfies while driving at high speed and brag to their friends. That again is yet more evidence that they were given notice of this danger, and how they should have responded is for a jury to decide. Now, Snap's response is, well, we did respond. We have this warning, and I'm going to get to the warning in a moment, but that doesn't disprove foreseeability. Yeah, maybe they can argue to the jury that the warning alone was enough, but it doesn't change foreseeability. They know that there is a danger. There's a second question that goes to breach as to what you should do about that. But just the idea that they decided to address this with a warning, that doesn't change foreseeability. Evidence number 5, this is in May of 2015. We have a police officer, Chris Cognat, who sends an email and it says, quote, my 19-year-old mentee mentioned one of the filters states MPH, miles per hour, might encourage kids to drive fast. Made sense to me. She and her friends snap all day long, and there's a exclamation point when they say that. This is how a lot of us learn about technology. I go back to that hearing in 2016, and I was trying to explain how the speed filter worked to Judge Azeri, and he said, quote, I don't tweet her. And I thought, oh, Jesus, am I going to have to explain that it's a tweet and it's Twitter? And I said, no, Judge Thacker's going to get that. I don't need to explain it. But point being, this is how it works. So you've got a police officer who knows a teenager and he reports it up the chain essentially to SNAP. And he is saying, yeah, as a police officer, this makes sense. This is what they're going to do. And the phrase, she and her friends snap all day long, that's an important context here because that's the type of behavior we're dealing with. And it goes to this idea that, oh, well, if we just put a one-time warning, one warning that pops up the very first time you use it, that suddenly that's all that's going to be enough. That's just not how this works. And Snap certainly knows that. Now, the other thing Snap says about this email is they say, well, you left out the rest of it. The rest of it shows that it wasn't a danger. Everything I'm about to say here is, again, for a jury to decide. So first, Mr. Schaefer, in response, so he's responding to the police officer. He says, quote, that's certainly a reasonable concern. All right, so they recognize this as a concern. And then he says, I haven't heard of it being used that way, though that's certainly reasonable. Okay, great. So I don't know if that's true or not, and I think it's entirely plausible given all the other emails and discussions I just talked about that. In fact, he did know that, but whatever. He now certainly knows about it and says it himself. And then he says, so it may be that those folks are more likely to show the car speedometer instead. And so what he's saying there is he doesn't think that teenagers would use it in this way because, quote, the speedometer on the speed filter is not as accurate as the speedometer on the actual car. I don't know where he's coming up with that. I mean, that's just not how teenagers do this, and it's not how Snapchat works itself. I mean, if that were truly the case, everybody would use the finest cameras in the world. We would never use our phones. Their entire business is based off the idea that if you create an app like this, teenagers will be incentivized to use it. Point being, these are all the inferences that the jury gets to decide. I'm sure they'll make a great closing argument on that, and we'll counter. And they'll decide it, but all those inferences get drawn in our favor. Type of evidence number 6, and then I'll get to number 7, and that'll sort of close the evidence on foreseeability, is the trophies. So during the same summer that these emails were from the police officer were coming, SNAP employees were debating the use of trophies. And one of the trophies that was being debated was basically a speed filter trophy. It was trophies that you would get if you were going certain miles per hour. Somebody basically said, we're encouraging people to commit stupid acts, so we can't do that. And so then they sort of said, okay, well, we'll only give the car emoji one at certain miles per hour that, or, you know, like, I forgot the exact range. I don't want to misquote it, but it was less than 100 miles per hour. And then that they would increase it to go above 100 if you were on a train. Anyway, they didn't end up doing those. We agree that those weren't actually implemented by SNAP. But the point is that they know that there's a linkage between what you put in a filter and what people do. That's the whole reason that they decided not to do those speed filters. The specific trophies was because they recognize that risk. And so again, a jury conclude, well, if you knew that about the trophies, why didn't you understand that about the speed filter? Again, a question for a jury to decide, but they did in fact understand and just chose to disregard that risk. The other part that's important about the trophies, because I think there's been, I don't think there is, they have made this argument that, we allege in the complaint that there were trophies, and now there's evidence that the trophies were never linked explicitly to the speed filter. That's not the point. In fact, as Dr. Alter explains in his expert report, there's two things going on. Number one is SNAP never tells people what the trophies are. That's part of the game of it, is you got to go find the trophies. We're not going to just tell you what they are. It's like the Pokemon thing where you go chase after the Pikachu. And I saw people do that as well on the Beltline, which is even scarier, seeing somebody running with their phone in front of them. But in any event, point being, that's part of the game. And so that uncertainty itself encourages people to try to see whether that they'll get a trophy for using the speed filter. The other part of the trophies, the other point that Mr. Alter makes, and is frankly something that we had alleged even before the point was made by Dr. Alter, is that the 100-mile-per-hour snap is itself a trophy. It doesn't need to be explicitly linked. That desire to post that type of snap is itself a trophy. And there's a phrase that we use from Dr. Alter's report throughout our brief is there was somebody commented, I think it was on an Instagram post, I'm not sure exactly where. This was after the speed filter was disabled and people were sort of reminiscing about the speed filter. And the quote was, "You're not using it right if you didn't touch 100." That's the type of effect that this had on people. And that's the type of foreseeability evidence that exists in this case. Last thing is the warning, which we talked about a little bit already. But the point here is that the warning itself is evidence of foreseeability. It's not the other way around. It's not, okay, well, we gave a warning, therefore we should just know as a matter of law that no one will ever use in this way. And Dr. Alter makes 2 points about this. Number one is, and I always think about the movie Inception whenever I think about this point, it primes people to do this. When you tell them, don't snap and drive, it puts in their head the idea that you could snap and drive. Particularly with teenagers, that type of effect is quite significant, but you don't even need teenagers. I mean, one of the reasons that we sometimes don't want to give limiting instructions or we don't want to object when somebody says something is when you do it, you draw your attention to it. And that's the same principle in effect with that warning, especially a one-time warning that just simply says snap and don't drive. And, you know, all these, not all, but the emails from March 2015, May 2015, those are all coming for 2 years after they have announced the product, or roughly 2 years, and they've had the snap warning. So when Chris Cognac is saying, look, this is a problem, and I wanted to raise it to you, the warning had already existed at that point and clearly wasn't working. The second point that Alter makes is that there's a doctrine of reactance. Basically, you tell a teenager not to do something, they're going to do it. Probably out of sort of oppositional behavior, a desire to test boundaries. And, you know, like I think most of you have teenagers, and so you know better than me. I don't need to educate anybody on that. But when it comes to social media in particular, it is something that happens. So that is the sort of scope of all foreseeability evidence. I think mostly what I heard from opposing counsel was the warning issue, which we already talked about. And then the second issue was the idea that there had never been, that they knew about or produced in evidence that we had seen, a prior incident with the speed filter. There were subsequent incidents, but not before the Maynard incident. And that's why I started with the totality of the circumstances test. And when I talked about the CVS versus Carmichael case, well, in our briefs, we talk about how you're not required to have a prior act. It would essentially create what they call a one free bite rule, which I now understood comes from dog bite cases. Somebody once said, isn't it about apples? I was like, no, it's about dogs. And that would just be an absurd rule. If you know that the jury can conclude that they knew about the risk, you don't have to wait for somebody to be seriously injured like this. And for that reason, it goes to the jury. All right, I'm going to transition to issue number 3, which is whether there was a design defect. And then issue 4 is the causation questions, just to sort of preview the next ones.
All right. And the only thing I have left that was open loop is the Stringer case. The site's 263 Georgia 641, because Kathy's going to ask me for it later, and I'm going to go ahead and do it now.
Yeah, I think that is very useful.
All right, we're ready.
Okay, so let's talk about design defect evidence. So we've transitioned from the analysis of whether there's a duty to guard against this type of misuse. And then the question becomes, okay, well, what did you do? And does it satisfy the risk utility test? So 2 important legal points at the beginning. First is expert testimony is not required. I was trying to read the slide that they had put up saying that expert testimony was required. And I remember looking at it, and well, first I couldn't see what the citation was, but the only citation that I saw anywhere on that was a federal case, a federal district court case, not a Georgia Court of Appeals case, not a Georgia Supreme Court case. And the case that we have cited, S.K. Hand versus Lohman, the Georgia Court of Appeals opinion, is clear that expert testimony is not required in every case. Now, I will recognize that in many cases it may be necessary, but this isn't one of those cases, and I'll explain that in a moment. Second important legal point is that The jury is the one who decides whether the risk utility test has been satisfied or not. It's not a situation, this is not a medical malpractice case, where you have to have the expert say, I declare a SNAP has failed the risk utility test. The risk utility test is a bunch of factors like, was it foreseeable? What's the utility? What's the benefit? I mean, the actual test itself is something that the juries do. The inputs that they get, some of those inputs can come from experts. That is what the test analysis is. So those are the two important legal points. Now let's talk about the evidence. I'm going to start with the expert evidence, and then I'm going to go to the non-expert evidence. But before I do that, I do want to make this point about the risk utility. It really is. The ultimate conclusion is simple. What is the benefit of this speed filter? I still don't know what it is. I think the only thing I heard from opposing counsel and all the depositions, the only thing I ever read, and I think I heard opposing counsel use the exact phrase, creative self-expression. That's it. That's all they said. And one of the problems with that is, why did you need the speed filter to do that? If you take away the speed filter and keep everything the same about Snapchat, what is the loss? What is the benefit to creative self-expression that we've somehow lost? The only thing we've lost is 100-mile-per-hour snaps. There's nothing else that anyone has identified that would be somehow important that would be taken away from that. And again, not for the court to decide whether that's the outcome that you would conclude or what I would conclude, for a jury to decide that. But that's why this is ultimately a simple risk utility analysis at the end of the day, because there is no benefit and there is serious concerns and risk. All right, so let's talk about the expert evidence. The idea that Dr. Alter does not have a risk utility opinion, did not do a risk utility analysis is simply false. We've quoted this in our brief, but I'll read it here again. Quote, Snap's decision to introduce the speed filter is among a handful of the most egregious product design decisions. The benefits of the speed filter are trivial and dwarfed by the cost. I don't know how anything could be clearer. I mean, we cited even more. Despite the obvious risks, Snap introduced and retained the speed filter because the value to the company exceeded the feature's appearance cost. This sort of cost-benefit analysis is inherent in business decisions. In his own words, he's doing that. Now, what instead you heard was a question posed by Snap's counsel that said, quote, did you in a scientific way endeavor to list out or determine from users what the benefit of the speed filter were? And there's a bunch more to that question. But let me just start with that first phrase. Did you in a scientific way list out or determine from users what the benefit of the speed filter were? That's not his job. That's not what the law requires. The law is not what risk utility Crystal McGee got from the speed filter. It's what Snap understood. That's why it's a price liability claim, not a user claim. We're asking, and what Dr. Alter did is from Snap's perspective, their design decision. So when you ask a question like that and he says, no, that's not part of what I did, he's saying, no, I did not study it from a user perspective because that's not the relevant test. And the second part of this question, and this is Alter's deposition at 145 to 46. The second part of the question is, and then do an actual business-like or scientific risk analysis in paper or on notes or in writing related to the speed filter. There's no legal requirement that you put a risk utility down in a formal paper or in notes or in writing. He's an expert witness. He gets up and testifies and explains his analysis and opinions. His expert report, which is 36 pages, explains that. But there's I don't even know what a formal risk utility analysis is, to be honest. And even if that existed, whether there was some scientific standard in which you do that, the whole point of the risk utility analysis under banks is that it's a flexible standard. It involves a number of questions. And when we're talking about a question like this, where there's no dispute as to how you get rid of the speed filter. I think the language was, quote, simple code change. That's all it takes. So we're not talking about costs. And when we talk about benefits, quote, one of many creative tools, again, not a necessary tool, not even something that they've explained that it's really important for teenage development to be able to post a 100-mile-per-hour snap. There's no expert that says that. There's nothing there. That's all that is needed here. I think we also heard that we have no expert opinion on warnings. also not true. Dr. Alter testified and in his expert opinion report talked about it specifically. That's where I used the 2 points about the inception reference, that you basically incept somebody with this idea and the reactants. That is from Dr. Alter. So we clearly have a expert opinion on the warning. I will say and do agree that we are not at this point contesting the idea that a better warning would have made a difference. I agree. We're not advancing that. We're not saying that, okay, if there'd been a better warning, it would have changed this outcome here. But that doesn't mean we don't have an expert opinion on warnings. We clearly do, which is that the warning that was given, SNAP knew or should have known, wouldn't have made a difference. And that's exactly what Dr. Alter says. This is going a little bit into the Daubert side of things, but I did want to just address it real quick since we're talking about Dr. Alter's opinions. There was an argument made about how there's no studies of accidents or car wrecks. A cohort study, I think sometimes described as a control group study. And yeah, that's true. And I think I heard opposing counsel even admit this. That's not a requirement of science. You're not required as an expert to do a double-blind, randomized, controlled study group. It's not the only way to do that kind of analysis. We heard that from Dr. Alter. We also know that that's not something that's reasonably possible in this type of situation. I talked about this in the briefs, but how would you isolate somebody from social media influence? I mean, are there teenagers that don't know about Snapchat? I don't know where they are. I use the example of the Amish, maybe. We could just do all of our studies on them. That's not the way this works. You also can't just do it by historical data as well, because car technology changes. You have changes in the way that roads and rules are regulated. All that changes. And so the idea that you could only testify about this if you had that kind of study, that's just not possible. And again, we'll get into this more when we get to the Alter motion, which will be after lunch at this point, is that the ruling that was referenced, it was correctly referenced by opposing counsel about what Judge Rogers in the social media MDL, she granted in part a motion to exclude Dr. Alter's opinions. It really is limited to his opinions about Meta's actual knowledge. And I think that was like part of opinion A. And then it goes through B, C, D, E, F, G, M, N, O, and denies the motion on everything else, including rejecting the specific argument about having empirical research based on studies. Court said that's not required. And so, you know, we'll get to it. Obviously, Your Honor has a discretion, is not bound by a ruling by another trial judge, particularly one in federal court. But if you applied that, at most, you're limiting a small part of it. Last couple of things about the risk utility analysis. Dr. Bowie, there was some argument that he didn't conduct a risk utility analysis, that he didn't personally conduct it himself. An expert doesn't have to do that. An expert doesn't have to conduct their own study in order to say that you didn't do one and that there's no evidence that you followed what would be reasonable standards in this case. So that's not required. And more importantly, and we'll get into this when we get to the Bowie testimony, he's talking about specific design issues. And again, that's why I talked about the input. So juries get certain expert testimony, but they don't have to have it over the entire scope of what they're dealing with. This is not a medical malpractice case. This is not a toxic tort case either. Neither of those things are required. And that's where I'll sort of end on the risk utility before turning over to causation. The kinds of cases where expert testimony are needed on all points are very different from this type of case. There are, for example, like toxic tort cases or medical malpractice. But when you have a case like this, where there is specific evidence that the jury will hear about what Crystal McGee did, what her other passengers in the car were doing, what they were thinking, that's why I led with the the Heather McCarty affidavit, is that can bridge any gap. So what Dr. Alter says is that the demographic that Miss McGee is in, the teenagers basically, they're heavily influenced by social media. And, you know, on its own, we probably don't need an expert to say that, but he explains how and why, talking about things like brain development, reactants, all these different things. it's clearly has opinions about McGee. What he's not saying, and what they're trying to sort of use to say that he has no opinion about McGee, is he's not saying that McGee is any different from some other teenager. He's not saying, okay, well, she's special. She has like a particular vulnerability to social media. Now, if they want to put up McGee to say, oh, I was very different from everybody else, they can do that. And we'll put up evidence from Heather McCarty saying, no, that's exactly what she was doing. We'll put up evidence from Henry Williams, who said, quote, everybody was doing it. He was literally saying the speed filter. And I'll get to this more in the causation, but everybody was using the speed filter so much that he described an 80-mile-per-hour snap as normal, nothing crazy. That's the kind of desensitization that had occurred. And even with McGee, we know from her, if we trust and accept Snap's data, that let me get the exact number. She had been using it, I think, something like hundreds of times a day.
37.
37 times a day. And so the idea that she wasn't influenced at all by Snap is just not true. Certainly a jury could find otherwise. All right, so I want to now transition to the causation issues. All right, so we have three different causation issues that have been raised by Snap. The third one will be pretty short, but let me just sort of outline them so you know where I'm going. First causation issues, they say, well, McGee and Henderson weren't using the speed filter. Our data proves it. And then number two is they say, well, no, even if she was using it, she wasn't using it because of something or even if she was driving 100 miles per hour, the speed filter didn't contribute to it. And then the third part is that McGee is the sole intervening cause. So let's start with whether McGee was using the speed filter. Starts with a spoliation order that Your Honor issued. That alone would end this question on summary judgment. And now let me clarify a couple points about the scope of this. So first, we're not arguing that the spoliation order decides all summary judgment issues. And the first time you're hearing me mention it is on this issue specifically, because we agree, we didn't argue it and weren't suggesting otherwise. So that is a bit of a straw person argument that the other side has made. Number two, Your Honor's order is clear. I read this in the reply brief from Snap. They said, well, the order doesn't address whether McGee was using Snapchat. It certainly does. I'll read from it. You may presume that the cell phone, if produced, would have contained information harmful to Crystal McGee in defending this case, including evidence that McGee was using her phone and the Snapchat app at or around the time of the crash. And Your Honor even bolded that language starting from including. So Your Honor's order does allow the jury to presume that Crystal McGee was using the Snapchat app at the time of the crash. And Snap is entitled to put up their evidence to the contrary. They can put up their data, they can put up their witnesses, they can put up McGee, but that's something for the jury to decide. Number two, Your Honor also addressed in that order the idea that Snap had no role to play in spoliation. Your Honor specifically found that Snap contributed to that, and that's why that ruling was made. And we're not here to argue a motion for reconsideration. The spoliation order by itself is a basis for denying summary judgment, and in fact is required under controlling precedent that we cited, including the Baxley case, that where you have a spoliation issue that renders, quote, a fact rendering summary judgment inappropriate. So that's number one. Now, number two, let's pretend there was no spoliation order and we weren't dealing with that. This issue would also go to the jury. Before I get into why Snap's data doesn't show that McGee wasn't using the speed filter or Snapchat at the time, I want to talk about a principle about summary judgment here. So it is a well-accepted principle. I think everybody understands that speculation alone is not enough to prove a point. But what we are dealing with here is something different. We have two competing direct evidence. We have direct evidence from witnesses saying that McGee is using Snapchat. She's using the speed filter specifically. And then on the other side, they've got their direct evidence that no, our data says that she wasn't using it. The question we're dealing with now is not speculation, it's how do you resolve that conflict. And when you have that type of conflict, a jury gets to decide, and they're free to disbelieve the other evidence if they think there's anything wrong with that evidence. So it's not like we stood up here and said, Your Honor, they have produced this data and this data doesn't definitively rule it out. It doesn't say one way or the other. If that's all we had done, if all we had in this case with the data, I agree with you. Summary judgment would be probably required at that point. But that's not what we have here. We have this testimony. And the only case that they pointed to that would suggest any kind of other standard is the Scott versus Harris case, I think 2007 or 2008 United States Supreme Court opinion, where the video evidence in that case, quote, blatantly contradicted the testimony. And what courts have said that you have to meet in order to satisfy that standard, this is not, this is the super summary judgment standard that you have to meet in order to satisfy that. This is from a Haley versus Amazon.com, a Washington Court of Appeals case, 522 P3D 80. To be clear, the Scott exception applies only when the moving party submits neutral, unimpeachable, irrefutable, and unrebuttable evidence that clearly demonstrates the truth of the moving party's evidentiary submission. So it's an incredibly high standard. We've cited cases where, for example, this is a railroad company. They had an event recorder data, and the plaintiff put forth an expert that said no, that there are problems in the accuracy. And the court said, okay, well, you don't meet the Scott standard because it is that high of a standard. So if there's any problems with their data, it's a question for a jury to decide. So let's talk about some of the issues with their data. Issue number one is that the spreadsheets, the Excel spreadsheets that they produced with Blizzard data, that's not a forensic tool. That is not something that establishes a clear chain of custody as to how that data exists. Spreadsheets can be modified. They can be edited. Those are all things that we know from basic spreadsheet data issues. And SNAP has said, well, you didn't object to spreadsheets, production of spreadsheets. There's two problems with that argument. Number one, this is their argument. So like we have our witnesses. This is why I started with this idea of how you deal with direct evidence. We already have our witnesses. So it's their burden to prove that their evidence meets the Scott versus Harris standard. So we don't have to do that. Number two, the issue is not that they produce something in a spreadsheet. We're not anti-spreadsheet people. The problem is they have not provided evidence that explains how they take that data from their analytics database and get it into the Excel spreadsheet. They say, well, they do what quote is called big query searches. So they've got this big, I think it was described as sort of undifferentiated mass of analytics data. And then they use these, I guess big query is like an interface to search through that. Okay, well, tell us, what are the searches? How is that done? Who did those searches? What are the terms? So that we have this chain of custody from your analytics data to this spreadsheet. We don't have that. There's no witnesses. And in fact, when we asked their 30B6 to explain how it was done, the 30B6 couldn't answer who did those searches and why it proves that no changes were made. And in fact, as our evidence indicates, SNAP couldn't even rule that out in the testimony that we have provided. So that's the first problem with their Blizzard data, is that those spreadsheets and the way that they're produced and the evidence that's been used to sort of authenticate it doesn't satisfy the standard. And so there's no requirement. This is not a discovery issue. We're not saying, oh, well, we need this evidence and you're not giving it to us. It's the evidence that you've provided to the court and we're going to provide to a jury doesn't establish the Scott standard. Second problem is that SNAP didn't produce the source code. Now they claim, well, we can't identify what version that McGee was using. Well, you didn't produce any versions, anything that would allow us to understand how that backend data gets translated. And again, this is not a discovery issue. It's a question of the sufficiency of their argument for summary judgment. So it's up to them to prove that this evidence is, again, going back to the language from the Scott cases that apply it, neutral, unimpeachable, irrefutable, and unrebuttable, and it doesn't have any of those things. Next problem with their data is there's another database, essentially, that involves operational backend data that our experts have indicated would be more accurate. Dr. Boyce said that. Again, they don't produce that data as well. Not a discovery issue, an issue with meeting the sufficiency of their evidence. Now, how does that get reflected in the data itself? We have numerous problems with the data. Location data is inaccurate. We went through with the 30B6 witness in like, I don't know, minutes, seconds, short period of time. It showed that Crystal was in Griffin, that she was in Myrtle Beach, she was in Nashville, and a couple other places that you can't humanly believe possible in the short amount of time that was there. There are thousands of sequence IDs that are missing. I think for Kaylin Henderson, another person that we haven't talked about yet, but who was in the car, she had 6 million sequence IDs missing. And that is something that Mr. Fong Lee and some of the other data employees of Snap say shouldn't have happened. What they say in those affidavits is, even if there's a loss of connectivity between the phone and Snap, that once the connectivity is brought back, the events get transferred onto Snap. So those sequence IDs will be there. I think Mr. Sen, I'm not sure how to pronounce his name, but says that, you know, it's an extremely rare possibility. Well, there's 16 million versions of that have happened, and Snap's witnesses have no explanation for that either. Snap admits that there's at least 4 possibilities. Events can be lost between the phone and the server, that Snap didn't include all the relevant data, that we didn't preserve all the events, and then a 4th one, not from Snap, but from Dr. Boy, that a power loss in the phone means that these events never get recorded. Snap admits this in their 10K filings. So when they report to investors, they basically say, look, you know, people are using our app even more than what we have data for because we don't always get all the data. And so they tell that to investors, but yet they want to tell the jury in this court that their evidence was essentially perfect and didn't have this problem. Now, the argument that we've seen in the briefs is that I think this is sort of the extent of what I've seen, at least, is, well, there are no problems on the night of the incident. Our data, even if you spot them all, these other problems, on the night of the incidents, we don't see any sequence IDs. And that just doesn't make any sense. If you have all these problems with your data, if you have 6 million sequence IDs, the thing that you can't explain and you say shouldn't have happened, then how do we know that the sequence IDs that you gave us are in the right order either? There's no basis for that. There's no reason a jury would be compelled to conclude that. And when they're deciding between these 2 competing events, that's the kind of thing that they get to decide. The example that I gave in our briefs is if someone lies to you 6 million times and say, oh, but this one time I'm not lying, you're entitled to believe that no, in fact, they're not telling the truth. All right, so the next proximate cause issue is, so let's say the jury can believe and find, based on eyewitness testimony, that McGee was using this speed filter. The question is, was she influenced by the speed filter to go at this speed? And the easy answer is yes, the jury can conclude that. They include that from the affidavit from Heather McCarty, that the Court of Appeals, in its the last appellate opinion we have in this case, basically after the remand from the Supreme Court, said that this is evidence that would establish causation. And we also see this in Dr. Alter's report. And again, I go back to the phrase that he reported from somebody who's reminiscing about the speed filter, quote, if you didn't touch 100, you weren't using it right. That is evidence that they can conclude was motivation here. I talked about this a little bit earlier. Henry Williams, who admittedly testifies that he doesn't think, or he says that Crystal wasn't using Snapchat and wasn't using the speed filter. But during that same car ride, he says, but Kaylin Henderson was, and that she was showing him, Henry Williams, a photo from the night before, snap video from the night before, where, quote, it was a normal car video, nothing crazy. It was an 80-mile-per-hour snap. Everybody was doing it. So it's for a jury to decide whether this is the type of influence that Crystal was likely to have experienced. She said in her own words, but certainly it was going around, even in the moments before the crash or time before the crash, that it's something that was there. Dr. Alter goes through a number of other ways in which the speed filter contributes. It gamifies the act of driving. It turns it into a social activity. And these are all things that a jury can conclude contributed to this. This does go probably more to Dr. Alter's opinion, but I do need to mention it. The idea that simply because he didn't read McGee's deposition, he somehow can't offer any opinions on causation. That doesn't work for a number of reasons. Number one, she denies using the app. I don't know why that would make a difference for his opinion if she's saying she's never using it. He's entitled to rely on other statements, which he did, about Heather McCarty saying that she was trying to post it to get on Snapchat. She was just trying to get to 100 miles per hour. And regardless, this all goes back to the point of his opinion is about the demographic. And if they want to argue that Crystal was somehow different, that's an argument they can make to the jury. Last proximate cause issue that identified was whether McGee's misuse was the sole intervening cause. That just goes back to foreseeability. If it's foreseeable, generally, we don't have to prove that they specifically knew that this one person was going to use in this way. If it was reasonably foreseeable that teenagers, young adults would use the speed filter in this dangerous way, that means it's not a question of sole intervening cause. It's a question of contributing, whether they were a contributing factor, not a substantial factor, but contributing factor. And that's another issue that I think comes up again and again. Question is asked of Dr. Alter, or is it your opinion that the speed filter made Crystal McGee drive this fast? And Dr. Alter's answer is, I don't use the phrase made because that implies a level of compulsion that's not how this works. It's contributed to, encouraged. And that's also consistent with how Georgia law treats causation. We are not a substantial factor jurisdiction. We're not a jurisdiction that requires you to prove that, it put her in like a trance-like state. It's simply some contribution. And if they want to tell the jury, well, it's 99% McGee and 1% Snap, then they can do that. But that's not something that we decide on summary judgment. Last two things, then I'll wrap up in a lot less time than my opposing counsel. I know he had to set the stage, so it's always going to be less when you talk second. Punitive damages and 13.611. I'll keep this relatively simple. On punitive damages and on 13.611, we're arguing just one thing: conscious indifference to the consequence. That's it. Not stubborn litigiousness, not frivolous litigation behavior. It's just a question of, did Snap know about a danger and then not take care to address that danger? And we do have evidence on this from an expert. Our expert, Adam Alter, used, quote, the phrase, one of the handful of most egregious product design decisions. And in addition to that, we have the evidence that they basically did nothing other than the warning. The warning is the only thing that they can point to as how they address this danger. And it's for a jury to decide whether that is care, especially when even after you have the warning, you've got people saying, you've got the reporter, you've got the police officer warning and saying, warning Snap, saying, we still have this problem. And as Dr. Alter has opined, as what they should understand as an industry, social media industry, is that teenagers are not going to follow that warning. And that's certainly an issue a jury can decide. Taylor versus Devereaux case that we cited in our briefs, Georgia Supreme Court opinion from 2023. It's like 100 pages about punitive damages caps and whether they're constitutional. But at the end of that very long opinion is a question about whether, in that case, there was evidence of punitive damages where the employer did a background check. So this is a sexual assault case. Employee sexually assaults a 15-year-old. And Devereaux says, well, we did a background check. Background check came back clean. And they said, well, that shows we exercised some care. And the court said, maybe. But a jury could say, no, in fact, that that background checks are not foolproof. And the warning here is basically the equivalent of background check. If all you had to do was just do one background check and nothing else, there would never be any negligent or hiring or retention claims. It requires something more. And in addition to that, we also can consider for punitive damages post-incident behavior. So we cited the law on this in our briefs, but we know from the evidence in this case that there were incidents. Opposing counsel agreed that there are post-incident crashes involving the speed filter. And what that evidence shows is that the reason that they maintained the speed filter is not because they thought, oh, well, nothing could ever go wrong. It's even after Mr. Maynard's crash, they continued to maintain it, knowing that this had happened, and knowing that a warning didn't prevent anything there because of cost reasons, or sorry, profit reasons. So there are no costs to the speed filter. It's profit reasons. They believed, and the speed filter was getting wide usage, that is their overall model, a business, that the more engagement, the better. And we'll get into this when we talk about Alter, Dr. Alter, and the attention economy. But basically, the idea is we just got to extract any second of our times. And so if we can get you for 5 seconds while you're driving the car to send a snap of how fast you're going, that's part of their business model. And certainly opposing counsel is free to tell the jury that teenagers have been driving fast and recklessly for all of history. And we're going to stand up and say social media makes a difference. And I'll leave it with this point about social media. I think I've made one movie reference. Maybe this will be my last one. And before the lawsuit, there was a movie called The Social Network. I hope everybody's seen it. It's a very good movie. You know what's coming out this year? It's The Social Reckoning. It's the sequel to that movie. And that's kind of where we are in this case. When I stood up in front of Judge Azari and was trying to explain what a snap was, when I used the phrase pics or didn't exist, he didn't know that either. We're well past that. We all know social media has had a huge influence on our lives. What the jury will be deciding is how and whether that happened in this case. That's what this is about. It's about using our tools to resolve this intensely disputed case. Unless there are any other questions, I will sit down and we can go to lunch.
No, as always, well organized. Thank you so much. Mr. Masterson, obviously it's 12:40. I'm looking at lunch. Of course, if you want to give additional argument, we'll let you. I assume you want to get up, and how long do you think you need?
10 or 15, I would say.
Let's try to finish this before lunch, and then we'll take the normal amount of lunch. So we're just shifting lunch a little bit later, but we'll take the normal amount, and then we'll do the others this afternoon. So,
Sounds good. Thank you.
all right.
So the last thing said sort of emphasizes the point, both to foreseeability and certainly to whether there's clear and convincing evidence of punitive damages. He's talking about this movie, Social Reckoning, that's coming out. I didn't even know that. I hadn't even seen the preview. But the idea of convincing a jury to sit over there in that box that about Snap's knowledge and its conduct and whether it was reasonable, whether the warning sufficed, based on a movie that gathers the data that of all this information that happened after, does not affect the liability decision before the court on summary judgment. It's not fair. It's horribly prejudicial, but practically it's just not information that was available to him. Okay. And so the evidence in the case needs to be looked at closely, because there were a number of times where I heard counsel talking about what they wish the evidence was or painting with broad brushes, but there's no actual evidence supporting it. I'm kind of going in reverse order if you can't tell.
no, we're good.
So in terms of contributing factor, substantial contributing factor, the causation standard, although it involves a toxic tort case, I would point the court to Scapa Dryer versus Knight, Knight, which is at 299 Georgia 286. And it talks a little bit about why you can't just say something generally like all asbestos causes mesothelioma, and you can't say something generally like all teens are affected. Because, I mean, the reason for that is obvious, right? The reason you need to talk about Miss McGee, the reason you need to read her testimony if you're Dr. Alter, is because this is about Miss McGee's use of the app. This is about whether she was influenced by the app. This is whether she was influenced by the app to put her foot on the accelerator. There's a completely separate overarching argument to be made to the jury that it ain't the app that causes people to do something. It's personal responsibility that causes to do something. That can't be decided today, I admit. But what can be decided is there sufficient expert proof based on actual evidence in the case with scientific methodology applied to it by some experts that are qualified to do it, to get to a point, right, where we can answer a causation question. And again, I understand, and And sometimes I'm a plaintiff's lawyer, and sometimes I might argue, right, things I wish had been the evidence. But he talks about Dr. Alter. Well, Dr. Alter didn't have to review Miss McGee's testimony, some of which I showed the court, but the whole deposition's available. Oh, he could just rely on McCarty's affidavit. Guess what else he didn't review? McCarty's affidavit, right? That's a statement that's not true. Could that be evidence that contradicts what Miss McGee said? Sure, right? It could. However, he didn't take the information about the person, about the app at the time she was using it. He didn't limit his analysis to what had happened before that accident. And I know Your Honor knows this, but this was the first accident, right? This is the first one, right? And so post-accident conduct, right, can be considered for punitive damages, but it can't be considered for foreseeability. And one thing I want to caution, right, and I would say the same thing to the Supreme Court with all due respect, right? I understand what the CVS versus Carmichael case said. In fact, it led to an entire passage of legislation after it was passed. And what it applies to is a negligent security case. This is not a negligent security case. This is anywhere close to a negligent security case. And product liability, which I've been doing for 26 years, has a different set of laws than premises liability as it relates to most issues at play. Can foreseeability as a word be present in both? Sure. But for example, we don't use the same premises liability standard because one, it applies to a different statute under Georgia law. Two, although you can look at it for guidance, it's not determinative or shouldn't be of the court's decision, because if you follow the Carmichael case to its logical conclusion, you would grant summary judgment for us because Miss McGee testified that she was aware of the hazards. But open and obvious, right, of a hazard to a product isn't alone enough to defeat summary judgment under product liability law, right? And so you can't have your cake and eat it too. You can't say, I'm going to apply premises liability law when it helps me, but I'm not going to take the benefit to the defendant, right, of open and obvious as a defense that completely destroys that claim under Carmichael or under anything else. Carmichael's talking about, you can look at the totality of the circumstances as it relates to what a property owner or manager of property knew about crime on the premises in relation to what the people who got hurt by the crime knew. That's what it's about. So moving on from that, right, in terms of the standard here as it relates to foreseeability, the foreseeability is one thing. It is what the documents and evidence that SNAP actually knew or should have known, right? That's the first part. But then there's also, you have to take that and you have to apply, right, some sort of reasonable standard to it, right? And I heard counsel say that you don't need an expert under Georgia law, and the court shouldn't be persuaded that because of the SK Hand case, SK Tool, I'm gonna have that wrong. Can somebody help me with that? SK Hand case. The SK Hand case does not say that. What the SK Hand case says is at the pleading stage, you don't need a 911 9.1 affidavit to file with your complaint. That's what that case, as it relates to this issue, is about. It doesn't say you don't need an expert for product liability. In every state of which I'm aware, federal and local, an expert is required to talk about a highly technical issue and the standard of care and how you apply foreseeability to your acts and omissions when you're talking about a highly technical skill. The federal case we cite says that, but also all the other cases said it. Now, I will agree there might be some challenge, right, to either of us coming up with a product liability case to hit each other over the head with in this kind of product liability case. Why is that? Or why might that be? Well, because most of the time, right, somebody doesn't file a lawsuit when somebody takes a product and illegally and intentionally uses it to hurt somebody. That explains probably almost entirely why there's not a big body of case law on this analysis, right? But it's despite that, right? The job for this court is to look at foreseeability, to look at it in terms of what was going on in the early days of this type of software engineering development design, and then have somebody come in and say, you know, I participated in that. I have experience in that. That was my job, right? And has expertise. It's not reasonable, right, to have not reacted, right? It's not reasonable. The warning wasn't enough, right? I heard argument from counsel, but there's no opinion from an expert, which is the law in lots of states, although I am not sure that there's one directly on point in Georgia, at least at the state level, but it is the law in most design defect cases, right, that evidence of a warning will defeat a design defect claim, an adequate warning, right? They don't have an expert who is qualified to do so to present to the court to defeat summary judgment that the warning wasn't adequate in curing the design. He just said that there was discussion about distracted driving, and that's true, right? They knew, I think, right? I think everybody else did too, but they knew that driving while using an app was dangerous. And they said, don't do it. I mean, I'll play the testimony when we get to Bowie's section or motion, but Dr. Bowie agrees, right? He knows exactly what the warning says. He knows exactly what it's meant. And no expert says that warning, I've analyzed it. I'm an expert in warnings, and that is not sufficient to prevent the foreseeable misuse, illegal foreseeable misuse, disregard of a warning. They don't provide that opinion, one, because Dr. Alter is not qualified to do so, which will come later, but also because it's an asinine proposition that can never be supported by an expert. He spent a lot of time talking about the metadata, the Blizzard data. Okay, I'm not going to respond to that at this point, other than to say the testimony of Dr. Bowie and the motion associated with it, and the testimony of Dr. Alter and the motion associated with it does inform on the metadata and its reliability. But remember, coming to the argument related to the first part of the analysis, right? Which is in terms of looking at whether or not Mr. Maynard could have avoided the consequences of this accident, whether the Blizzard data shows she was using the speed filter or not, or whether you believe McCarty or McGee on that point, or the Blizzard data over that, right? Their experts are not giving witness credibility opinions. They can see that in their briefs. And so the only thing that answers the question is, did Mr. Maynard appreciate the risk, right? So they would have to have either an expert or a fact witness say, Mr. Maynard couldn't appreciate the risk, whether the car was coming at 55 miles an hour, 100 miles an hour. He sees headlights. They're coming in the direction he's intending to turn. They want the court to accept they didn't appreciate the risk of that. One, it flies in the face of common sense. Two, there's absolutely no evidence in record to the contrary supporting it. That's where that part of the analysis ends, and there's nothing they've done with an expert to change it. The second part of that was that, well, Mr. Naveen stood up and said, well, they forgot the part where our expert will testify that he couldn't perceive the speed she was coming at. I mean, right, or something like that. I guess he's a fine lawyer, and I'm sure was not misrepresenting anything to the court, but Sean Alexander testified that he's not giving an opinion. He's not an expert on perception or what Mr. Maynard perceived. So the record is silent as to what he perceived or whether he appreciated the risk. What it's not silent on, and what all of the evidence, including from Mr. Alexander, show, is that she was coming down the road. He could see her for a half a mile at whatever speed she was going at, and he broke the law in at least 2 or 3 ways. He failed to yield coming out of the intersection. He failed to yield going into the left lane. There was some idea that some fact witness had said, well, he went fast and then slow, But their accident reconstructionist looked at the data from the car, and he said he never turned the car left. So there's no evidence disputing that. He said accelerated across 2 lanes of traffic, and that if he hadn't done that, and he said everything else being equal, the accident would not have occurred. That's not our expert. I didn't pay somebody to say that. That's their expert. And that's what's before the court. It's unchallenged. And I agree. And I said it before and I'll say it again. It is not all the time it comes. This comes up and it is appropriate for the court to grant summary judgment. But in this case, it is. It's directly on it's on all fours with the Weston case. Okay. But the idea, which is what he cited to, oh, well, you never grant these in rear end collisions. This isn't a rear end collision. A rear end collision is everybody's going in the same lane of travel and the person behind doesn't stop and they run in to the back person and moving traffic or something like this. This is according to their expert, a case where the person pulled out, accelerated across 2 lanes of traffic, and in a matter of seconds or whatever, was in a lane when the driver of the other car says, I never expected in a million years that they would not stop in the right lane. And the rules of the road apply both ways, right? However, if it's something that you can expect, which is that sometimes people will go faster than the speed limit, or it's something that you expect that sometimes people drive across 2 lanes in front of you, and that defeats the claim, then that would work both ways. That's not the standard. The standard is there's no evidence saying he could not see her coming, that he had plenty of time to do that at any speed, because I mean, we didn't get into this, but the speed at which he's coming over a half-mile period gives him ample time to observe her coming and make a different decision. And there's no conflict in the evidence of that. It's 22 football fields. Beyond that, he makes a decision 3 times not to yield or to break the law, with knowledge that pulling out in front of somebody, just like the lady in Weston, can have dire consequences. And for that reason, the court, and in the absence of anything from any expert or any fact witness to the contrary, right, should grant summary judgment on the avoidable consequences argument, as we made later. The Stringer case, the one that Southeastern Stages versus Stringer, I think that we talked about, it says that to establish reasonable foreseeability, more than mere possibility of an occurrence must be shown. I'm gonna leave it there, right? Because we're gonna talk about what later after lunch, what these experts said or testified to, what their opinions are purported to be, and the support based on actual evidence or fact that they use to reach it. And so rather than do that now when everybody's undoubtedly hungry, I will stop talking and request that, I forgot one thing. I'm so sorry. Last thing, on the fee dispute, the conscious indifference argument that was asserted, again, fails under the standard based on the evidence that's currently before the court and based on what SNAP knew, right? There's no evidence even approaching conscious indifference based on what it knew at the time it released the app. And to Naveen's point, in a product liability case, it is true, right, that a manufacturer can continue to consider evidence after the product leaves their hand. That's where the whole recall law comes in, right? I mean, you know that the seatbelts aren't working or something, you can recall the car. But that only stretches the post-sale knowledge and information that may be considered up until the date of the accident. And the state of that is there is no evidence of another accident or somebody being hurt. There are some discussions in various forms. The idea that we have actual knowledge or constructive knowledge of a change.org petition that every single witness said they'd never seen is is not good argument to defeat summary judgment. Some of the other things that are there and produced in Snap's production can be considered, but they come nowhere near to the level of establishing some type of actual knowledge that one could be consciously indifferent to, or that rises to the level of punitive damages. And so those claims, based on the status of the evidence, we would submit should be summarily dismissed. Thank you, Your Honor.
All right, thank you. All right, any last thoughts before we wrap up the? Anything
Yeah.
else?
I could say more, but I've already said.
All right,
Yes, Your Honor. On behalf of McGee, if you're inclined to rule that Snap favors for the rules of consequences, I would say that would also apply to Crystal McGee.
okay, thank you for bringing that to my attention. I appreciate that very much. Okay, anything else before we break for lunch? All right, I've got 1 o'clock, slightly before 1 o'clock on my calendar, so let's do this. Let's break. I had the order ready in case y'all got grumpy with each other for y'all to all forced to eat lunch together. I'm not going to issue that order forcing you to all eat lunch together because y'all been wonderful today. So again, if you get chippy, that's fine. That's our job. There's plenty of restaurants within walking distance of here, so y'all can spread out as you wish. And so let's circle back here. Let's give y'all time to go and pivot to the afternoon. So let's be back here at 2:30. That gives y'all an hour and a half to both look at your notes, prepare for the afternoon, grab lunch, and then start back here at 2:30. Anybody, anything else on the record before we adjourn? Or no, before we break for lunch?
This doesn't need to be on the record. I
Okay.
just have a question about timing.
All right, we're off the record then.